May I have your lordship's kind leave to mention a matter, your lordship. This is a notification matter. If your lordship could kindly give the direction to list this matter under the heading of mentioned matters
Today is
on
not
Monday.
the day of mentioning.
May I
You
have
please
my
don't mention it.
mention a matter, my lord. This is Jalpaiguri matter, my lord. I'm trying to leave to file my review application without the certified copy, my lord.
What is the urgency to filing a review application without certified copy?
My lord,
When the order was passed?
3rd January, my lord.
3rd January.
My lord, this was against the matter where pre-deposit was the issue, my lord. The authority has given me 4 weeks to comply with the order by the 15th of March, my lord. So if this order is not reviewed prior to that, my lord, I will be my right to pay the balance amount of the fund pre-deposit will go.
Mention on Monday.
My lord, if my lord grants me leave, my lord, by Monday, I'll apply today and I'll file a certified copy.
Okay.
My lord,
Leave granted.
it has to be endorsed, my lord, that leave is granted.
Call the list. I am reading the only operative portions of the order. Under the above observations, the instant writ petition is appears to be meritorious and the same is allowed. Impugned memo dated 18th May 2023 issued by the respondent number 2 is hereby quashed. Respondent 2 is directed to transfer back 1429 customers to the petitioner who are initially transferred via email dated 19th August 2023. Respondent 2 is directed to complete the exercise within 4 weeks from the date of passing of this order. Disposed of.
Extremely grateful. Obligement.
Next.
My lords, I appear for the petitioner. This matter relates to the administrative staff.
Which for the Bose Institute.
Mr. Shukanto Chakraborty Malad is appearing.
He was there.
He was there, and Mrs. Chandri Yalam is appearing for the Union of India. May I start in the meantime? Perhaps they will join.
Yes.
My lord, till now, my lord have heard two set of writ petitions, where the endeavor was made to treat the symptoms, and perhaps, my lord, the underlying disease was not gone into in as much detail as it should have been. So, my lord, my endeavor before your lordship would be to show that the action taken by the Bose Institute through the impugned order dated 5th of May 2020, whereby they have declared the previously subsisting pay revision and promotion policy, which was implemented in 2008, as null and void. And my lord, what they did, they have reverted me back to the position that my clients held during the time of their respective joining. My lord, this I say, my lord, would be against the settled contours of law. My lord, I will subsequently deal with these impugned orders, but my lord, I'll give you an outline how I intend to deal with this matter. My lord, there are two set of facts. Right? One relates to the implementation of revised pay scale and promotion policy in the year 2008. But why I emphasize on that? Because the very ground the group of officers has taken is that the 2008 policy is without any due approval from the competent authority. So my first endeavor would be to show before your lordships that the 2008 policy, which was implemented with effect from 22nd of December 2005, has due approval from the competent authority. And my next endeavor would be to show how the entire exercise that was undertaken by the authorities post 2017 in the garb of implementing the 7th CPC My lord, what they did, they went back in time. My lord, they have dealt with the duly implemented policy under which my clients were enjoying the benefits, and they all of a sudden they have decided, no, my clients are not entitled to get the benefit under that policy. So my lord, firstly I will deal with the procedure through which 2008 policy was validly implemented, and secondly I will assail the entire action taken post 2017 in the garb of 7 CPC. So my lord, these will be factually, these are the two, my lord, limbs of my submission. So my lord, may I start?
You are submitting that the policy decision of 2008, which is under challenge,
My lords,
do you approve?
give approval, my lord. I'll show to your lordship.
Okay.
I'll draw the sequence from 1979.
Your Lordship, they have a certain cans which my learned friend had to.
No, on the last day I said that can, there is no meaning because the main matter is being taken up for hearing.
What can? You
My
are
lord, the
appearing
can
for?
was,
For both institute, Your Lordship.
Yes.
my lord, the can was for recovery. So my lord, since there was an objection from my learned friend on the other side that since the main matter is ready for hearing, there is no need to get into the can. So my lord, I'll place my main case.
It may be recorded that he is not pressing.
Now,
on the
why not?
cans.
Those cans are pending. I am pressing my main application.
Your Lordship, the cans, and for the cans, I need to file an affidavit as.
My lord, recovery.
as-
My lord, for recovery, they are seeking
Yes.
an affidavit. My lord,
Yes,
I'm pressing my main case, my lord, now.
As in the grant which was given to them, it was subject to recovery. It was
Then what is
specifically.
the can? What is the
My
can
lord, can
number?
is against the recovery made from the retirement dues of my client.
Okay, it is your prayer for can.
Well, those were my prayer for can, that since the recovery was bad in law, Rafiq Masih stares at their face. But now, my lord, since we are on the main petition, allow me to argue.
You can proceed. Can be heard along with the.
Huh?
Yes, yes. My lord, let him argue, my lord, on merit.
Yes.
My lord, only one thing.
If you want to place the objections, affidavit in opposition or anything against the
My
can,
lord,
you can file.
my lord, may I just indicate
My lord,
this?
I can.
May I just indicate this? My learned friend has very, very candidly taken a stand that they don't stand on the point of recovery. Rafiq Masih settled law, they will not object to.
My lord,
Why they are insisting
my lord,
for an
I think,
opposition?
my lord, I think if I may clarify one thing. My lord, since my learned friend's grievance is that we have recovered. My lord, we have not. My lord, if my lord learned friend can show, my lord, I have gone through his can applications also. If my learned friend can show before your lordship that we have recovered a single paise, my lord, I am agreeable to, my lord, withdraw
I'll
my
take
Yes,
2
okay,
minutes.
okay.
That's what I'll
Let
take
me
it.
proceed with the main.
Main.
My lord, only my lord with a caveat. My lord, in case my lord, affidavit in opposition is required, lordship kindly allow me to, my lord, use an
Against the
affidavit
can.
against the can.
Okay, you can use it. No issue.
My
Within a week or two, my lord,
But
if
my
that
lord,
can be filed.
the main application, these two petitions, my lord, he
Today
has
we are
filed.
hearing
Main.
7078.
My lord, 70769, 7078, and 7084.
Oh, three matters.
My lord, I
Okay,
think
madam.
if your lordship takes up the main matters, because his can is related to main matters,
Yes.
Main time
Lord,
is-
then
main
everything
time
can be
आगे
sorted
Okay,
out
I will pass the order. I will take up
Lordship.
the can along with the main matters.
as your lordship.
Okay, 70
My lord, 69.
7069.
Let's 7084, 78, and 7084. My lord, three matters.
Okay.
My lord, since I was, my lord, in my submission, I said that the first,
You are
My-
appearing on behalf of the all petitioners.
all the
on
petitioner. My lord, I must indicate the 7069 and 7084 relates to administrative and 7078 relates to technical. So, my lord, since technical matters have been heard in detail, my lord, I'll not address your lordship much on that. My endeavor, my lord, would be to deal with 7078 and 84. So, my lord, I'll start with 7069.
7078 in respect of a
Technical, my lord,
technical stuff.
my lords.
You are appearing on behalf of technical as well as the
Yeah,
administrative.
but I'll start with 7069,
9 and 84.
my lord. These are for administrative stuff. 69. No, type on.
লিখে দিচ্ছেন। that's all. 7069. 7069. Yes, please proceed.
So, my lord, my first limb of submission regarding validity of revised pay structure and promotion policy. My lord, in sometime in 2005, the authorities, the respondents before your lordship, have felt the requirement to revisit the subsisting policies for the employees. My lord, in this backdrop, a structural reforms committee was formed. My lord, that structural reforms committee had given its final recommendation. My lord, this is the background in which the 2008 policy was brought in 2008. So my lord, kindly takes page 54, annexure P4. The 2008 policy, my lord, is not a case that all of a sudden, one fine morning, the authorities decided, let us come with a policy. That was not the case. A thorough, my lord, deliberation went behind this policy, and thereafter, only after getting all the necessary approvals, this was implemented. My lord, page 54. My lord has that.
Yes.
My lord, it reads, final recommendation of the Structural Reforms Committee of Bose Institute in its meeting held on July 7 and July 8, 2006 at Centenary Building of Bose Institute, Kolkata. Page 54.
Yes.
My lord, kindly sees the composition of this committee. Professor A.K. Barua, former Director, IACS, Kolkata. R.K. Bhadauri, Associate Director, VECC, Kolkata. Professor Dipankar Chatterjee, ISC, Bangalore. Professor P.C. Sen, Department of Chemistry, Bose Institute. My lord, these are the composition of my Structural Reforms Committee. My lord, now kindly sees the introduction.
Yes.
Bose Institute has a glorious past and has at present an excellent level of research activity, which has earned many accolades. Apart from basic research in diverse areas of physical, chemical, and biological sciences, Bose Institute has of late successfully initiated work on technological development and linkage with industries are being established. To keep Bose Institute at the cutting edge of science and technology, the Council of Bose Institute, let kindly note the next part, with liberal help from the Department of Science and Technology, Government of India, have suggested a number of steps for improving the quality and the procedure of recruitment of faculty. This includes the possibility of offering competitive scales of salary to the prospective faculties, flexibility of designation of a faculty position, quick hiring system, etc. Suggesting improving infrastructural facilities have also been made. It's also strongly endorsed that the overall quality and competence of non-faculty staff, note non-faculty staff, should be upgraded via a continuous training program and appropriate skills for them. Commensurate with the qualifications and experience should be implemented for the efficient use of technical and administrative support. This is the background. The Bose Institute as well as the Department of Science and Technology felt the need to revisit and revise the subsisting pattern of emoluments, pay structure of the employees. It kindly takes the last para then. As regards to the service conditions pay structure of all category of staff, the committee felt these needs to be modified for attracting quality scientists and improve performance of the institute. As such, the committee opined that the pay structure and other service conditions as being amended in IACS, a sister concern funded by DST, be completely at par with the IACS and be adopted in Bose Institute also. Same view was also taken by a high power anomaly committee under the chairmanship of Sri B.K. Chaturvedi, the then Joint Secretary and Financial Advisor, DST, during May 1987. Well, kindly take note, there was previous subsisting policy decision that there has to be a parity between all the policy decision in respect of the employees at Bose Institute and IACS. Well, this is the background. Well, at the next page, my lord need not trouble because this pay structure career advancement of academic staff of Bose Institute. My lord, the first part deals with the academic staff. My lord, now I am concerned for the administrative staff, my lord, non-academic, my lord, which your lordship will find at page number 59.
Yes.
My lord has that. My lord, page, it's at the bottom. Pay structure, career advancement scheme, promotion rules, etc. of administrative and technical staff of both institute. Well, the background information and the general observation. The pay scales, allowances, and retiring benefits of the administrative and technical staff of both institute were changed from those of the University of Calcutta to those of the Government of India in 1987-88. My lord, prior to 87-88, it was, we have drawn the service benefits and the pay pattern in tune with the pattern prevailing at Calcutta University. But
Yes.
since 1987-88, my lord, we have shifted to the central pattern. The really needed changes are to ensure that the quality of personnel recruited should be compatible with the overall objective of the upgrading the activities of both institute and are similar to those enjoying similar skills in the other research institutes funded by the central government. The promotional rules should be implemented in such a way that the members of the staff improve their qualification and capabilities for getting promotion. This is the background in which the authorities have deemed it necessary to devise the service pattern so as to attract better quality of employees and to improve their service conditions. Now, my lord kindly takes page number 67. What is the exact thing that is troubling the authorities?
Yes.
My lord, they say that time scale of which was recommended under this policy, this after this my lord, restructural committee has opined that there has to be parity and we should implement the same time scale of pay that was prevailing at IECS. This is troubling them. Well, what does we mean time scale? Does it mean that suo moto, by virtue of attaining a residency period, you become entitled for promotion? Well, no, that is not the case. Time scale or residency criteria is merely an indicator which makes you eligible for being considered for the promotional avenue. Apart from that, my lord, kindly sees the third point at page 67. The candidate shall be subjected to interview as well as other tests to assess the actual capability. The results of interview along with ACRs shall determine the suitability of the candidate for promotion. If found unsuitable for promotion, the case may be considered after a year. So, I'll pause here for a moment. This is the background in which the Structural Reforms Committee has recommended for time scale. And my lord, the particular provision of this recommendation shows that this time scale is not automatic. It will make you entitled for being coming within the zone of consideration. So, my lord, now after this, kindly takes, my lord, this Structural Reforms Committee's recommendations, my lord, what to be considered by the Finance Committee. My lord, there is a procedure how the policies are implemented at both institute, my lord.
Yes.
Initially, an expert body is formed in this case. Now, that body has given its recommendation. My lord, before placing the recommendation before the Finance Committee, the council, my lord, it has to have the approval from the Finance Committee, which is somewhat the nodal agency authority for taking final view on the financial aspect of the matter, because it will have financial implication. So, my lord kindly takes the minutes of meeting dated 7th of January 2008, which is at page number 73, where these recommendations came up for consideration. My lord is at page 73.
Yes.
My lord, kindly sees the heading. Minutes of meeting of the Bose Institute Finance Committee held on 7th January 2008 in the committee room of Centenary Building of Bose Institute, address such and such. My lord, the members present, kindly sees the composition. My lord, the chairman is the additional chief secretary, Higher Education Department, Government of West Bengal. My lord, the next member is joint secretary and financial advisor, DST. My lord knows that the financial advisor, in terms of 13 January 2017 document, he is the representative of the finance, Ministry of Finance, in the nodal ministry.
Yes.
My lord, next is the director. After that, my lord, the registrar. And my lord, even the accountant general, A&E, West Bengal, is also part of this committee, but on that particular day, he was not present. My lord, why I'm emphasizing on this? Because a question was put. Who is the competent authority, whether the DST or the Ministry of Finance? My lord, my endeavor would be to show before your lordship at all relevant point, the Ministry of Finance were kept in loop about each and every transaction that happened regarding the implementation of 2008 policy. My lord, the accountant general, my lord, cannot be said to be, we cannot say that he is not part of the Ministry of Finance. My lord, the accountant general acts on behalf of the ministry. My lord, even otherwise, the joint secretary, financial advisor, DST, he is a representative of the Ministry of Finance in the nodal ministry, my lord. So all throughout, they were the stakeholder in the decision-making process at Bose Institute. Now, my lord kindly takes the relevant agenda, which is agenda number, item number 2.5, page 75. On the left-hand column, your lordship will find the particulars, and the right-hand column, my lord will find the decision, action taken. My lord, I'll place the left-hand column first. Agenda item 2.2 in bracket 5, consideration of the status of the recommendation of the Structural Reforms Committee as well as non-academic promotion policy of the institute. I have shown to your lordship 7th July 2008. My lord has seen that recommendation. Now that recommendation has come up for consideration before the finance committee. My lord, what is the action taken? As regards the case with non-academic staff, the finance committee noted that the chairman of the council and the secretary DST had promised that a committee of DST would look into the matter and a final conclusion would be arrived at within 3 months from the date of meeting. That is 13th of September 2007. Well, 13th September meeting was held. Well, this finance committee meeting is dated 7th of January 2008. So, well, on 13th of September, a commitment was made that they are trying to take a decision on this issue, to form a committee and come up with a decision within 3 months, which was not taken. Now, the financial advisor DST informed that though the deadline of 3 months was already over, there had been no progress on the matter from the DST. The director, the registrar, as also the deputy registrar and the account officer all impressed upon the finance committee how very difficult it had become to run the institute in the circumstances. Well, the next para is very important. In this context, the director drew the attention of the financial advisor DST and the chairman of the finance committee to an office memorandum dated 8th of August 1979. Well, this is a office memo issued by Dr. T. Ramasamy, the then secretary of DST. Well, I'll come to that. Received from the DST, Government of India, Ministry of Finance, Science and Technology, signed by the then Secretary Professor I stand corrected, Professor M.G.K. Menon. This office order stated that as regards pay scales and common interest of staff, there should be parity between the Indian Association for Cultivation of Science and Bose Institute. It went on to further state that any proposal along these lines should be discussed between IACS and Bose Institute so that uniformity between these two institutions would always be maintained. The director argued that in the face of the document, the proposed committee was redundant and the implementation at Bose Institute of the revised pay structure and other service benefit in line with the currently in vogue at IACS had the automatic approval of the DST. My lord, I'll pause here for a moment before proceeding to the next para. My lord has seen in the previous council meeting, the secretary has proposed for formation of a committee, which will take a call on the fate of the recommendation made by the Structural Reforms Committee. Now, my lord, the Structural Reforms Committee's report was in line with the recommendation made by the IACS. My lord, I have shown in the second paragraph, it has written that there is similar policy in vogue at IACS. So, my lord, in view of the 1979 memo, my lord, the authorities, the finance committee members have consciously decided that the formation of this proposed committee would be of no use. Because after going through the entire process, our sister concern, another institution under the DST, has approved a similar process. So, my lord, in view of that, they have got the automatic approval of the DST. So, formation of a committee for this purpose is not required. My lord, the next para. The committee also agreed with the arguments. My lord, the finance committee, comprising of all the members, have agreed to the arguments of the institute and decided that an extraordinary meeting of the finance committee be convened on 31st of January in the chamber of Joint Secretary and Financial Advisor DST at New Mahadali Road, New Delhi, to formulate its final recommendation in the matter. So, my lord, I will now take your lordship to the relevant circular of 1979, which has been emphasized upon at this meeting, which my lord will find at page number 46, annexure P4. My lord, annexure P3 it is. Better copy not. अच्छा नहीं ना लेकिन अब let may I hand over a better copy, a typed copy, the document. The better typed copy, my lord.
No, page 47 is a better copy.
My lord's clear.
Yes.
My lord, I'm placing the Government of India, Ministry of Science and Technology, Department of Science and Technology, and the details, my lord. The office memorandum dated 27th of January. No, this is 8th of August, my lord, sorry.
8th of August.
8th of August, 1979.
Yes.
Subject revision of pay scales of non-academic staff of IACS and Bose Institute. The issue of revision of pay scales of IACS and Bose Institute for the non-academic staff consequent to the revision of pay scales of these staffs in Calcutta University was discussed with the President, Director, and Registrar of IACS and Registrar of Bose Institute. When it was decided, the following points should be kept in view during the revision of pay scales. Well, at the very first point, there should be parity between IACS and Bose Institute.
Yes.
This is a considered view taken by the then secretary who was sitting at the helm of affairs at Ministry of Department of Science and Technology.
Yes.
Well, I'll not trouble with the second and third. It kindly takes the second last para, which starts at it is also desirable. My lord has that it is also desirable
Yes.
that in future matters of common interest are discussed between the two directors so that unified policies could be evolved in regard to the staff matters. It's long back in 1979. My lord, the DST has taken a conscious decision that there should be parity between its autonomous organization. particularly IACS and my lord, the Bose Institute. My lord, we have drawn authority. Since my lord, there was already a revised pay structure and promotion policy, which was recently implemented upon taking due consideration of all the relevant factors at the same point in time. My lord, the formation of a separate committee to again go into the merit and nitty-gritty of the recommendation placed by the SRC, the Structural Reforms Committee, was my lord of no use. My lord, this view has prevailed over the Finance Committee. And my lord, they have drawn their authority, and rightly so, on the basis of this 1979 document.
In the year 1979,
My lord,
Bose Institute
1970.
was under the Calcutta University.
My lord, the nodal ministry, my lord, back
Nodal
then,
Ministry DST.
pattern, the nodal ministry was DST. So my lord, they are drawing reference to the Calcutta University, but
Yes.
the main point is for all pay related pattern
There should be a
stuff,
parity.
parity with IACS
IACS and
Bose
BC.
Institute.
Bose Institute.
My lord, the Finance Committee has drawn the authority and decided, look, there is no need to form a further committee to again get into the same issue. It will be a sheer wastage of time. The DST has already taken a view on this subject. Let us go with the same policy which is at
Prevailing in IACS.
IACS. My lord, in view of this, the Finance Committee has recommended that this issue, this view, that since there is a prevailing direction from the DST and there is already a Structural Reforms Committee has recommended similar, my lord, policy at IACS, we should discuss this point, whether we can proceed with this policy in view of the 1979 order or not. So, my lord, after this, on 31st of January 2008, my lord, they have convened a extraordinary meeting of Finance Committee.
Yes.
My lord will find that at page number 46.
No, 46 is the
My lord,
memo.
my lord, sorry. My lord will find that as,
MK Menon. KGK Menon.
my lord will find that অন্য দিয়েছি তারা 46 টাই দেখেন দেখো পরেরটা দেখেন টাইপ কপি আছে my lord kindly takes 31st of January is at page number 81. My lord has that.
Yes.
And it reads minutes of the extraordinary meeting of the Bose Institute Finance Committee held on Thursday, the 31st of January 2008, in the room of the Joint Secretary and Financial Advisor DST Headquarters, Government of India, at Technology Bhavan. My lord, the members present again, my lord, same composition, Additional Chief Secretary of Higher Education Department, Government of West Bengal, Joint Secretary and the Financial Advisor DST, Accountant General and A&E West Bengal, the director and the registrar. Everyone was present, my lord, including if I may say so, two representative of the finance, the Accountant General, my lord, and the Joint Secretary and Financial Advisor to the DST. My lord, the agenda item number 2, consideration of the implementation of pay scales and other benefits of the non-academic staff of Bose Institute at par with those in vogue at IACS. The Finance Committee went over to recapitulate the brief discussion that had taken place with reference to the office memorandum number such and such dated 8th of August 1979 that had been brought to the notice of the Finance Committee in its last meeting held on 7th of January 2008. After thorough discussion on the issue again, the Finance Committee was of the opinion that so long as this letter from DST was in force, the parity between the Bose Institute and IACS in terms of pay scale and other service benefit in the respect of the non-academic staff should be maintained. Kindly see the finding. The committee is of the view that so long the 1979 is in force, there has to be parity between IACS and Bose Institute. Next, it observed, under the circumstances, the Finance Committee is of the opinion, now, Finance Commission felt that there was no scope for any further discussion for any empowered committee on this issue and resolved to communicate this view to the Council of Bose Institute at the earliest for consideration. My lord kindly recalls, the first Finance Committee meeting on 7th of January, the background was that they were contemplating to form a committee to consider the recommendation made by the Structural Reforms Committee.
Yeah.
Now this Finance Committee, taking in cue that there is nothing against the 1979 directive, so there was no need. And they have relegated this matter. They have felt they felt that there is no need to form any committee, and now they have relegated the matter to the next stage for approval. The matter now comes before the council in their 178th meeting, convened on 21st of March 2008, which my lord will find at page number 83, annexure P8, the very next page, my lord. Minutes of the 178th meeting of the Council of Institute, held on Friday, the 21st March 2008 at 10 a.m. in the committee room of the Centenary Building of Bose Institute at such and such. Kindly sees the composition.
Yes.
Kindly sees the composition. Who is the chairman? The person who is sitting at the helm of affairs at Department of Science and Technology. The then Secretary, Dr. T. Ramasamy. So, this committee, this council, which has been called upon to take a decision on the recommendations made by the Structural Reforms Committee itself, is chaired by the topmost person from the Department of Science and Technology. And they're talking about the approval. They're talking about the necessary due approval from the competent authority. Who is the next person? Director Finance DST. So they have, they have got all the intention. The finance was always kept in loop. The next is Member of Parliament. Then Professor Alok Bhattacharya, JNU, New Delhi. Shri Prasad Ranjan Roy, IS Principal Secretary to the Government of West Bengal. Shri Benjamin Lakra, Accountant General, A&E. Again, my lord, he is also there on the board.
Yes.
He is also part of the council. Shri Professor Shivaji Daha, Director, Bose Institute. Dr. B. Harigopal, Advisor, SCRC DST. And he is an invitee at the request of the Secretary DST. Again, he is from the DST. Professor Parimal Sen, invitee, Professor K.P. Das, invitee, and Professor Sri T.K. Ghodoi, Registrar. So, out of 8-member body, has seen 4 are from DST. And or if I may say so, finance. The Accountant General, the Chairman, the Secretary, the Director Finance, and the Advisor. So, in this backdrop, I'll take your lordship to the relevant agenda, which is at page number 86.
Page number 86.
86, my lord. '86. My lord has that?
Yes.
My lord, it reads agenda item 170.4. Consideration and approval of the minutes of the Finance Committee meeting held on 7th of January and 31st of January 2008, respectively.
Yes.
My lord, it further reads, the council noted the minutes of meetings of the Finance Committee held on 7th January 2008 and extraordinary meeting of the Finance Committee held on 31st of January 2008 respectively, and approved the same with the following observation on item 2 of the meeting held on 31st of January, which I have shown to your lordship. The chairman agreed, the secretary DST, agreed that there should be parity between IACS and Bose Institute in terms of pay structure and other benefits of the staff as indicated in the letter from Professor M.G.K. Menon, the then Secretary, Government of India. Dr. Ramasamy, in his capacity as Secretary DST, informed the council that not only should there be parity between IACS and Bose Institute, but he went a step further. But among all the autonomous institutions of the Ministry of Science and Technology, he assured the council that such measures were already underway at the level of ministry and would be implemented with proper approval at the earliest. Now I'll just digress for a moment from this position, my lord. I have shown to your lordship till the 170th meeting.
Yes.
My lord, the recommendation made by the Structural Reforms Committee, the subsequent decision arrived at in the Finance Committee meeting, and the first council meeting. My lord, the group of officer, which I'll come later in the course of my submission, has taken a view that this is the last point till which the authorities have considered the matter. And my lord, conspicuously, they remained silent on the final approval that followed this. And after this, I'll show 8th of April 2008 and 15th of April 2008, whereby the revised pay structure and promotion policy was implemented at Bose Institute by the then director. Then I'll draw the relation between the decision arrived, the fault in the decision arrived at by the group of officer and the actual approval accorded to this entire exercise. My lord kindly takes page number 40, annexure P2.
April 8th.
My lord. My lord, may I place it?
Yes.
My lord, office memo dated April 8, 2008. In pursuance of the terms of reference of office memorandum number such and such, dated 8th of August 1979, which I have showed to your lordship, issued by Professor M.G.K. Menon.
M.J.K. Menon.
Read with the report of the Anomalies Committee constituted by the then Secretary, Government of India, White DST Office Order Number 3rd of February 1987. In accordance with the instruction contained in the Ministry of Finance, Department of Economic Affairs, Government of India, letter number such and such, dated 17th of November 1983. And in anticipation of the formal approval regarding the parity between Bose Institute, IACS, and other similar DST-aided institutes, Government of India. The Director, Bose Institute, having been satisfied that the revised pay structure and career advance scheme was implemented in Indian Association for the Cultivation of Science with effect from 22nd of December 2005, and on the recommendation in the meeting of the chairman, heads of the departments, sections held on 8th of April 2008, has been pleased to order to implement the identical revised pay structure and career advancement scheme for non-academic staff, both technical and non-technical, of the institute provisionally with effect from the same day, that is 22nd of December 2005, for keeping parity between the Bose Institute and IACS, subject to the condition that the overpayment, if any, made thereby consequent to an otherwise decision by the competent authority, shall be recovered from the employees in a suitable manner. Well, this is in contemplation of a formal approval. And but this is the specific point taken by the group of officer that in fact there was no formal approval after this.
Yes.
My lord, I'll show to your lordship that my lord, the last
This
para
is
then.
the memo the group of officer assigned. This is the memo.
My lord, this
8th
is the
April
memo. 8th April, and my lord, kindly see the last para.
Subsequent,
Last para, my lord, the salient feature of the revised pay structure and career advancement scheme of non-academic staff will follow shortly. My lord, the subsequent memo with detailed guideline, my lord, came on the next on 15th of April, which is at the next page 48, 41. My lord, I'll place this, my lord. In continuation of this office memorandum number such and such dated 8th April 2008, the salient feature of revised pay structure and career advancement scheme of non-academic staff, both administrative and technical, of the institute at par with IACS are attached herewith. If there is any anomaly, that will be sorted out in conformity with IACS Kolkata by a committee to be constituted by the Director Bose Institute.
yes.
My lord, then follows the policy. Page 42. My lord, I'll place 3 clauses from this. My lord, for the purpose of clause 1, pay structure of the administrative and technical staff, 2 category, my lord, category A, non-group A, category B, group A. My lord, the scales were marked. Under category A, my lord, there were 7 scales. Under category B, there were 3 scales. My lord, kindly see the bone of contention, which your lordship has already known by now. That what was the main contention? That my clients are enjoying time scale of promotion. My lord, this is the policy. Residency periods for the purpose of career advancement of the administrative and technical staff. Scale 1 to 4, 1 to rather 5, it was 4 years, 5 to 7, 5 years, and 8 to 10, 10 years.
Yes.
But let have shown that this is mere a residency period. It will not make you entitled for promotion. There are other aspects, interview, ACR, everything has to be considered. Let be that as it may. Let kindly see the next para. Scale of pay of post. Designation of post for above mentioned corresponding scale of pay, minimum qualification of administrative and technical staff would remain the same as defined in the Bose Institute service rules and recruitment rule. My lord, kindly take note of this. My lord, the policy has not created a new post. There is no creation of post. My lord, there is no further financial implication. My lord, the subsisting Bose Institute service rule as far as the post and designations, my lord, will remain intact. And my lord, it is not the case that before this policy there was a vacancy-based pattern prevailing at Bose Institute. No, my lord. All throughout, my lord, it is time scale that was prevailing at Bose Institute. My lord, kindly takes take the 4th clause, career advancement scheme, promotion rules for administrative and technical staff. There should be 2 categories of scale of pay for promotion of administrative and technical staff as mentioned in serial number 1 under the heading pay structure of administrative and technical.
Yes.
But the member of the staff entering at scale 1 of category A can reach up to the scale 7 with increase of academic qualification and upgradation of capability. If the above mentioned criteria are not fulfilled, the members of the staff entering as helper A will have a suffix B to G corresponding to the scale of pay. If the appropriate qualification is attained, the designation of LDC will be given for granting designation to the technical staff. The same norm as for administrative staff will be followed. And next is important. The residency period for the purpose of career advancement of the administrative and technical staff, as mentioned at serial number 2 above, will follow. Well, then I'll skip over the next point. Kindly comes to subclause E for promotion of group A, category B in the scale number 8, 9, and 10. The committee would take into consideration the residency requirement, the educational qualification, experience, along with self-appraisal report and ACRs for the last 5 years, plus accumulated cumulative credit point. This is very important, my lord. These are the benchmark which will entitle you for promotion, not only the residency period. If the committee, after scrutinizing the report, feels that she would be competent to carry out the responsibilities required by the post of this category, it would recommend promotion to category B. If the committee is not duly convinced that the candidate is suitable, it might place the candidate in the same group with some added incentive, such as higher scale without designation, or reject the case. Such a candidate would not be eligible for promotion to group A category B within the next 2 years.
Yes.
Well, these are sum and substance. Residency period was introduced, which was nothing new. And my lord, the residency period would be a mere criteria to bring you within the zone of consideration. And
Zone of consideration for promotion.
The other requirements will follow. It's not that a UDC staff who attend for 4 years or 5 years, the day he attends 5 years, he will be promoted. No, that is not the case. He will just come within the scope of he will come within the scope of consideration. If he satisfied all the other criteria, my lord, if he is competent enough, he will be promoted. Otherwise, not. There is even ground for clause for rejection.
You are submitting that this is within the institute, both institute service rules and recruitment policy.
My lord, they have not touched. My lord, it is written. The service rule is intact. Clause 2.
Yes.
My lord, kindly then next takes. My lord, so till this point, the group of officer has considered. And my lord, I'll take your lordship back to the 8th April notification at page number 40, which the group of officer has harped upon. But what does it read? It reads that we are implementing this policy in anticipation of a formal approval from the
Yes.
competent authority. And my ladies further says that in case of an otherwise decision, these words are quoted in the group of officers report, which I'll come later. If an otherwise decision is taken by the authority, the competent authority, they are entitled to recover. So, my lord, till this point, no dispute. But my lord, a very important aspect of the matter was intentionally overlooked by the group of officers. Though the document was there before the group of officers, I will show to your lordship in the list of document that forms part of the group of officers deliberation. That particular document is there, which has accorded final approval of the entire decision making process in the 171st council meeting. Now, my lord, kindly takes that, which is very important, at page number 97.
Page 97,
My lord,
171st meeting.
conspicuously, the group of officers remained silent on this approval. My lord, minutes of the 171st meeting of the Council of Bose Institute held on 29th of October 2008 at 1:30 p.m.
Yes.
My lord, I've just missed one point. My lord, after 8th of April, there was one more important development. My lord, the 6th CPC was implemented based on the policy that was introduced in April 2008. My lord will find that is at page number 19, and my lord, this was dated 17th of October. Before this,
Before 29th October.
my lord. So my lord kindly takes the trouble, my lord, to come to page 90 before I take your lordship to this.
90.
90, my lord.
Yes.
My lord has that.
Yes.
This is a memo issued by the registrar. It is dated 17th of October 2008. And it reads, in pursuance of the office memorandum number dated 30th of September 2008. My lord, this 30th September 2008 was a notification. My lords knows that the CPC benefits are initially implemented for the PO central government employees, and subsequent to that, my lord, a separate notification issued for the autonomous organization and the statutory bodies.
Yes.
So, my lord, 30th of September was akin to the 13th of January 2017 in the present case. The Government of India, Ministry of Finance, Department of Expenditure, communicated by the Department of Science and Technology, Ministry of Science and Technology, Bose Institute is pleased to implement the recommendation of the 6th Pay Commission as contained in the aforesaid memo for the employees of the institute who opt for the same in accordance with the extent rule, identical to those for central government employees with immediate effect. So, my lord, 6 CPC benefit was implemented on 17th of October 2008.
Yes.
Now, my lord, then my lords kindly comes. My lord, there were two decisions, 8th April and 15th April 2008, and subsequent decision on 17th October 2008. One implementing the policy, the next implementing the, my lord, the 6 CPC benefits. My lord, these two came up for consideration before the council in the 171st council meeting, which I'll place before your lordship, page 97.
Yes.
My lord has the page 97. Minutes of the 171st meeting of the Council of Bose Institute held on 29th of October. My lord, again the composition. My lord, same. My lord, here the relevant agenda, my lord, would be 170.4, which is at page number 99. My lord has that.
Yes.
My lord, the left hand column is particulars and the right hand column is action taken. My lord, serial 4, 170.4. My lord, the particular reads adoption of pay structure and promotion policy, a pay structure and promotion scheme for the non-academic staff, both technical and non-technical, of the institute at par with IACS in the spirit of the letter from Professor M.G.K. Menon, the then Secretary, DST, Government of India. The council noted the action taken report as stated hereunder. Based on the decision of the council in its 178th meeting held on 21st of March 2008, the director on the recommendation of the implementation committee had provisionally implemented its identical pay structure and promotion advancement scheme as in force in IACS for the non-academic staff, both technical and non-technical, of the institute with retrospective effect from 22nd of December 2005. Further, to accord promotion to the eligible candidate employees both such and such under the newly adopted promotion career advancement scheme, the assessment promotion committee comprising 7 members has been constituted, and pursuant of the recommendation of the committee, the recommended candidates were promoted, upgraded to their immediate next higher pay scales from their respective dues. Now, the entire exercise undertaken by the director on 8th of April and 15th of April. Mallet Council endorsed the action taken by the institute in this regard. Mallet, I repeat, the council endorsed the action taken by the institute in this regard.
Yes.
What better approval? In what more categorical word you can have approval than this? So, Mallet, the structural reforms, the revised pay pattern and promotion policy, which was brought by the Bose Institute way back in 2008, well, it was duly approved by the council, which was chaired by the then Secretary, Department of Science and Technology. It has the representative of the members from the finance. So, well, this very aspect of the matter Well, it is conspicuously missing from the report of the group of officer, which is one of my principal challenge to the report. If a half-baked consideration, an improper, incomplete consideration of facts, eventually will vitiate the finding. If group of officer has not considered this recommendation, has not considered this 171st meeting, and without considering this, it comes to the conclusion that look, 2008 policy, there is no approval. They are simply relying on the 8th April memo saying that that was in anticipation, and they were again referring to 170th meeting saying that the then secretary said. It said that we will take step, we are contemplating, but they said there is nothing final on this aspect. I have shown to your lordship on record that it was final. Well, just before, so this is the first limb of my submission.
Yes.
Because when I started, I have shown to your lordship that there will be two limb of my argument, because since the group of officer, which otherwise has no jurisdiction or authority to deal with the policy, or what policy exists at Bose Institute, or what policy don't exist at Bose Institute, that was none of their concern. The scope of group of officer in terms of 13 January 2017 notification was very limited. For the purpose of implementing the benefits under 7 CPC, they were to look that in case there is disparity, they have to make a recommendation. And my laws knows if any recommendation that has penal consequences, it has to be, or civil consequences, my lord, if I may say so, it has to be prospective. That can the group of officer, without there being any authority, the finance has not granted them the scope to go and decide, to go and sit in appeal on all the policy decision taken by the Bose Institute. No, that was not the scope. Scope was very limited. Implementation of 7 CPC, look at the scope, parity or disparity. And my further submission would be, there was no disparity. I'll even show that from record. So this is my first limb of submission, where I have made my endeavor to satisfy your lordship that the 2008 policy was duly implemented with due approval.
Approved.
So I'll just trouble your lordship. I'll take your lordship on the group of officer recommendation, and I'll trouble your lordship on the next day about the second limb of my argument. This is the first limb where I have shown to your lordship that how the policy was implemented, where from the policy draws its authority.
Yes.
And on the next day, I will show the process for withdrawal of this policy. The process whereby my clients were reverted back to the post. They were put with the threat of recovery. Why this is illegal? So the chain of events will follow from 13 January 2017 and subsequently. I have covered implementation of policy in 2008, implementation of 6 CPC. Next day, I will start on the 7th CPC. But before that, I must show one more document as an alternative argument, my lord. That they say there is a case, there is a specific plea taken in the reply, which I will take your lordship in the course of my submission, that there is no formal approval, formal or written approval. My alternative case is, in 1999, 27th of January 1999, the Department of Science and Technology has issued a memorandum. It was for delegating the authority of the department to the councils of respective autonomous bodies under the institution. So that is my alternative argument to support my first limb of submission that the 2008 policy was validly issued. Kindly takes the circular, which is at page number 48.
Yes.
This is an office memorandum issued by the Ministry of Science and Technology on 27th of January 1999. My lord is aware that delegation of power is the usual thing in the ministries. The subject reads guidelines for enhancement of functional autonomy of research and development autonomous institutions under the Science and Technology Department institutions. Well, the government of India has been considering for some time the question of making the management in research and development autonomous institutions under the S&T department more flexible and responsive. Consequently, the central government have decided to enhance their financial and administrative autonomy in the manner indicated in the following guideline. Well, now since we are dealing with the promotional policy of employees, well, this is, in my respectful submission, is an administrative discretion bestowed on the council. And my lord, the relevant point about the discretion as regards the policy matters for employees, my lord will find Roman 2 Administrative Matters, page 50.
Yes.
My lord, it reads powers of the governing body, governing council to create posts. The scientific departments enjoy operational freedom regarding group B, C, and D. My lord, this is now referring to the department. You cannot delegate what you don't have. So, my lord, the department says that we have the authority to, rather the operational freedom to deal with B, C, and D category of employees. They are subject to DOP. They are subject to DOP MOF guidelines in case of Group A post. My lord, my clients are not Group A post. Once the strength of the different grades in Group A post is fixed, there may be no objection to the flexibility of allocating such post within each grade to pay discipline as per the requirement of the institute. Transfer of post among different grades, however, will not be permitted. There is no objection in granting horizontal and not vertical flexibility in reshuffling of the post. Well, my endeavor is to show, or rather emphasize, ministry has the operational freedom to deal with B, C, D employees. That this was delegated by virtue of this this circular. So, once you delegate that circular, do I need a separate permission? And this is my case without prejudice that there is a proper approval in the 171st meeting. But my alternative case, without prejudice to that, in view of this, do I at all require any permission if I deal with my group BC employees? What pattern they have, what policy they will be implemented? What if the government, if the central government start to poke its nose in all the administrative matter, then what is the meaning of autonomy? Why you call us an autonomous organization? You better deal with that. You better acquire all the autonomous organization, end the autonomy. Well, keeping parity with this autonomy, this circular was issued.
Yes.
So, I'll just trouble your lordship with one more document today. That is the group of officers, because on the next day I'll be dealing with the relevant the sequence of event that unfolded post implementation of 7 CPC, and how it has encroached upon my valuable rights which has accrued in terms of the policy which was lawfully implemented. So, my lord kindly takes the group of officers to I'll just show to the extent, because today I have made submission that this was a validly implemented policy, and I'll just show that paragraph, that portion of the group of officers finding that this policy has no approval from the competent authority.
Yes.
My lord will find since the group of officers report was not with us, your lordship will find it was supplied subsequently in the affidavit in reply. My lord kindly takes the affidavit in reply in respect of affirmed by Sujit Kumar Basu on March 20th, 2021. document. Affidavit in reply, March 20th. Affidavit in reply, 20th March.
Yes.
The other page 14. My lord, my grounds of I'm not going into my grounds of challenge. Today I'm just on the facts. So my lord, I'll just show
That the draft report.
the draft report. My lord, there is only a draft report. That's even a ground of challenge that I'll argue. You cannot take a decision. And my lord, I have got RTI reply to show. I've enclosed this copy. Initially, we have applied for the right under the Right to Information Act. We got this document and we were surprised. We have applied for the final report. We thought they would be more serious and sincere in dealing with this serious matters. But eventually, we were supplied with this draft report. We went in appeal before the appellate authority. We have sought for confirmation. My lord, the reply came that this is the only report they have.
This is the only report.
This is the only report. They have written it. I'll show the RTI reply. And this is the one which is circulated. So kindly treat it as the final report. Kindly treat this draft report as a final report for all practical purposes. This is this. If I may, my lord, I'll take your lordship through the sequence how I got the RTI, my lord, because this is part of the facts. My lord, kindly takes the page number 12.
Online RTI applications.
My lord, my RTI application. My lord, prayer for relief sought. The
Yes.
box. Wide my RTI application under reference. Page 12. Reply to against the DST reply. Respondent number 1. No. It is tomar touch reply. But I'll taste this. Wide my RTA application under reference. I have sought for copy of report. Recommendation submitted by the group of officers. ये तो রেকর্ড আছে আমি একটা স্যাটিসফ্যাকশন রিপ্লাই পাঠাচ্ছি এই ওটা দিয়েছি আমি এটা প্লেস করে দিচ্ছি না একবার ফ্যাক্টে I have sought for দেখি তুমি তোমারটা হলো I have sought for copy of report recommendation submitted by the group of officer constituted for considering and recommending grant of 7 CPC to technical and administrative staff of Bose Institute. Whereas, by an email dated September 25, 2020, I have been provided with a draft copy of said report containing numerous markings and overwritings. The said report does not bear the signature of all the members allegedly constituting the said group of a report. Being aggrieved by such incomplete information, I hereby request the appellate authority to kindly provide me with the final report, recommendation submitted by the group of officers constituted for considering and recommending grant of 7 CPC to technical and administrative staff of Bose Institute, Kolkata, based on which Department of Science and Technology has issued the impugned order 16th October 2019. This is my RTI reply because I was not quite surprised that this cannot be a final report. Now, my lord kindly takes the response of that RTI, which my lord will find at page number 22. My lord has that page 22.
Yes.
My lord, subject first appeal by such and such. I have gone through the online first appeal dated 24th of October 2020. The first appellate authority in Department of Science and Technology, after taking into consideration the online RTI application dated such and such, and the comments dated such and such of CPIO AI division, Autonomous Institution Division, observed that CPIO Autonomous Institution Division in his comment dated 4th November 2020 has clarified that the report provided by reply dated 25th September 2020 is the original and final report duly signed by the chairman and 2 members. My lord, it was a 4-member body of the group of officers. A copy of CPIO comments dated such and such is enclosed herewith, my lord, which is very important. My lord, kindly takes page 24, the comments. The appellate authority has enclosed the comment by the CPIO. My lord, the comment reads, the report of the group of officers was submitted as a draft for approval by the chairman member of the group of officers. Having found this draft report to be in order, the chairman and two other members of the group of officers approved the same by appending their signature thereon. Thus, the report provided to the applicant is the final report, even though a draft report is inscribed on the front page. The report is also treated as final report for all purposes and all subsequent decision of the department. Well, whatever we have, well, this is not the case that after this draft report they have issued a formal report. Well, the draft which was circulated among the members has not been considered. Well, if a report comes through a committee, there has to be a deliberation. There has to be consensus of mind. There has to be conformity between all the members. It has to bear the signature. Well, it is not signed by the director, who is one of the member. Can we proceed for such a serious thing on the basis of a report which is prepared in such a callous manner? This is one of there are judgments to that effect that no administrative decision can be arrived at on the basis of a draft report, on the basis of a report which is not signed by all the members. This is one of my challenge, and which I will argue, my lord, when I'll place the law. So, my lord, for the time being, my lord, why I have taken your lordship? Just to refer to that particular para. My lord, on the next day, I'll start with the 7 CPC, but I'll just place the group of officers report today to draw a connection between the 2008 policy and how they went after 2000 policy without authority. My lord, kindly takes the group of officer report, the draft report, if I may say, at page number 14.
Yes.
My lord will find there lots of correction, marking. On the top, it's inscribed as a draft report. So, my lord, the authorities, in my respectful submission, has not applied their conscious mind. Report of the group of officer constituted for considering and recommending grant of 7 CPC to the technical and administrative staff of Bose Institute, Kolkata. Department of Science and Technology, in terms of Department of Expenditure Office Memorandum dated 13th of January 2017, has constituted the group of officer in respect of those autonomous institutions under the DST where the non-technical administrative employees were enjoying promotion avenues better than employees of the central government. And this finding is utterly wrong, which I'll show to your lordship. The composition of group of officers was as follows. My lord, C is the composition. The additional secretary and financial advisor DST or its nominee, Dr. B.K. Shukla, head autonomous division or its nominee, Shri S.K. Sinha, director administration DST. Number 4, director, registrar, administrative officer, nominee of the director on the board of the institute. My lord, though it comprised of these members, my lord, this does not bear the signature of the fourth entity. It's not signed by it. This is my specific case. The meeting of the said group of officer in respect of Bose Institute was held on 24th of June 2019 at DST. The list of participants attending the meeting is annexed at Annexure 1. My lord knows, my lord have heard this matter at length. My lord, you are deciding on the fate of hundreds of employees. It was such a serious deliberation. But you chose to convene a single meeting. My lord, the 13th January document, when I'll rely in course of my submission, well, it has specifically carried out have this point that while taking a call on this subject, you have to take due consideration, rather give due consideration to the views of the staff member. Well, at 24th of June, the solitary meeting was convened. We were called upon to give a tabular showing that we are not in disparity with the other central government. We did. There was no subsequent correspondence, no subsequent decision arrived at. All of a sudden, this draft report comes. So, there was no deliberation at all. The terms and reference of the para 3, the terms and reference of the group of officer was to examine the pay packages of the respective autonomous body, taking into account the view expressed by the staff members. Let's kindly see. Where was the view taken into consideration? Absolutely missing. No consideration of my views. And ensure that the 7 CPC final package of benefits extended to the employees of these autonomous organizations is not more beneficial than that admissible to the corresponding categories of central government employees. Malat, we have shown that there is no disparity. The final packages recommended by the group of officers would be submitted to AS and FA DST for further concurrence of the ministry. Para 4, Dr. Shukla, head AIs, chaired the meeting and accorded welcome to all the members present in the meeting. Now, Professor Anup Kumar Mishra, acting registrar, Bose Institute, stated that AI Division DST, via its letter dated 7th of February 2019, has directed autonomous institution under the DST to withhold this 7 CPC benefit, whereby vacancy-based promotions are not followed. Kindly take note, vacancy, they are making it a sacrosanct case that in our country, the only legitimate way of promoting an employee is a vacancy-based promotion. My lord, I'll show that vacancy-based is not the only accepted form of promotion. Time scale is valid, duly approved, and accepted by the government. In respect of non-technical administrative employees, and such staffs are enjoying better service condition and promotion avenues than that admissible to the corresponding categories of the central government. Again, my lord, kindly look the scope, very limited. You find out your scope in case of if you want to implement the 7 CPC benefit, if you want to accept the fund from the government, you have to come in parity with the central government.
Yes.
Right? Does it anywhere record that no, you can go back, you can dig in past and find out what policies are in existence? The grant of 7 CPC to be put on hold till GO recommend the case. Acting Registrar Bose Institute informed the GO that DST, by its later dated such and such, had approved for grant of 7 CPC with following conditions. The conditions are enumerated. Even the 7 CPC was implemented. Now, para 7, Acting Registrar Bose Institute state that non-academic technical employees of Bose Institute were being given time-scale promotion since 22nd of December 2005. In terms of revised pay structure and career advancement scheme, non-academic staff, in support of his submission, he now kindly takes the stand, which is very important. Non-academic technical staff were being given the time scale promotion since such and such date in terms of revised pay structure and career advancement scheme of the non-academic staff. In support of his submission, he drew the attention of the group of officers towards DST OM dated 8th of August 1979, the letter by Professor M.G.K. Menon, wherein it was mentioned that there shall be pay parity between Indian Association of Cultivation of Sciences and the Bose Institute non-academic staffs. And IACS on an autonomous institution having the approval of DST on the recommendation of the SRC had adopted time scale promotion for its non-academic staff with effect from such and such. BI2 followed the footstep of IACS. The issued BIOM dated 8th April 2008 was having the approval of Finance and Governing Council of the BI dated 31st of August, January 2008 and 21st March 2008. The 21st October, though the clients of my learned senior friend is taking a stand which favors me. They are saying Bose Institute on record says that the SRC recommendation or the revised pay structure promotion policy implemented in 2008 had the approval of Finance and the DST. Can you take an opposite stand? The principle of one cannot approbate and reprobate at the same time. As far as DST is concerned, but DST may argue against it. Can Bose Institute today take a different stand than the one which has taken in 2019? I put this question to myself. You cannot put defense to something which you yourself have accepted. This is their stand in writing. They say that 2008 policy is validly implemented. Can they turn back and say, no, it was not validly implemented? And kindly mark this portion. This is very important. This is the stand of Bose Institute, the principal respondent. Now, the next para, The acting registrar, Bose Institute, also drawn attention of group of officer about presence of Sri K.P. Pandian, the then Joint Secretary and Financial Advisor, DST, and Sri Benjamin Lakra, the then AG, West Bengal, in Finance Committee meeting dated 31st of January 2008, and presence of Dr. T. Ramasamy and Sri S.C. Chawla, erstwhile Secretary, DST, and Director Finance, respectively, in the Governing Council dated 21st March 2008, in which the decision approval to this effect were granted. But again, the same stand that I am taking, my lord.
No, Bose Institute said.
But what, kindly note, my lord, the acting registrar also drawn attention of the group of officer about the presence of Sri K.P. Pandian, the then Joint Secretary and Financial Advisor, DST, and Sri Benjamin Lakra, the then AG, West Bengal. My lord, this is to show that the Ministry of Finance was
January 2008.
always kept in loop. My lord, this shows that they themselves are saying that the Ministry of Finance was always kept in loop. Meeting dated 31st of January 2008, and presence of Dr. T. Ramasamy and Sri S.C. Chawla, erstwhile Secretary, DST, and Director Finance, respectively, in the Governing Council meeting dated 21st of March 2008, in which the decision approval to this effect were taken, granted. So, my lord, what is it? They accept this case. The Bose Institute itself says on record that the policy implemented in 2008 had the approval of the council, and not only the council which comprised from members or rather chaired by the secretary, DST, has direct approval from the DST in that event. The chairman, DST, so the chairman of the council happens to be the secretary of the DST. So it was well within the knowledge of Department of Science and Technology, my nodal ministry. Can I have a better case than this? And this is the stand Bose Institute took. Well, they have even referred to the AG, financial advisor. Well, why all these? Just to show that the Ministry of Finance all throughout was aware about the happenings at the Bose Institute. And well, this policy was implemented to their knowledge. So well, they cannot take a contrary stand. Well, next para. Professor Misra and the staff representative present there contested that when 6 CPC has been granted by DST in the past on similar condition, then why at the first instant the mat this time had been referred to GO for implementation of 7 CPC in BI. In support of their contention, BI placed before the group of officers following documents. My lord, kindly sees serial number 9, Roman 9. Copy of the minutes of Governing Council meeting dated 29th of October 2008. Let the 171st meeting.
171st meeting.
There is no discussion, there is no whisper, but the document is before the group of officers. It finds place.
That is the approval.
That is the approval. But my lord will not find any discussion on that. I'll just take you lords. I'm just taking your lordship through this document. I'll deal with the legality of this document subsequently. But my endeavor today is just to show that how they can miss on such a relevant document, 171st meeting. Well, at para 11, the group of officers found that some of the submissions made by BI were without any supporting document. Hence, it was suggested that BI should furnish to DST within 3 weeks' time the chronology of events that led to adoption of time-scale promotion in lieu of vacancy-based promotion in their organization, along with justification available on record. Now, let para 12. BI, by its letter dated 16th of July 2019, furnished detailed chronology of events as desired by the group of officers, along with supporting documents. In addition to the documents already furnished in para 10 above, it has furnished the following document. Over and above para 10, further documents were submitted. Again, para Romans 16. My lord will find the same 171st meeting. My lord, Romans 17, your lordship. Page 16.
Yes.
My lord, kindly mark Romans 17, my lord. 16.
Yes.
The 171st meeting. Next para. In addition to the submission made by BI, the group of officers thought it prudent to consider as to whether such adoption of time scale promotion in respect of non-academic technical staff in lieu of vacancy-based promotion with effect from 22nd of December 2005 in Bose Institute, wide OM dated such and such, was implemented with the approval of the competent authority as contested by BI. This is very important. Now, they are leading to decide, they are going to decide or frame a question which was not within their authority. What they are saying, I'm again putting emphasis on this.
Yes.
In addition to the submission made by BI, the GOO thought it prudent to consider as to whether such adoption of timescale promotion in respect of non-academic technical staff in Bose Institute by OM dated was implemented with approval of the competent authority. Can they put this question? Do they have the authority to come up with this question and decide on it? A decision was taken by the Secretary DST in 2018. Now, this group of officers, which comprised of subordinate employees, can they put question on the wisdom and mandate of the previous secretary? One in 2008 and another in 1979. But their scope was very limited. They were called upon to find whether there's a disparity or not. And if they find there's a disparity, they can prospectively recommend. As regards the implementation of the 7 CPC, they cannot go back and dig in past and find out whether the 2008 policy was rightly implemented or not. They don't have the authority. Well, now they went in the wrong direction. They have digressed from the issue. Para 14, from the documents and records made available to the group of officers, the contention of the Bose Institute that having reliance on DST's earlier OM number dated 8th August 1979, the Governing Council of BI in its 178th meeting had accorded approval of pay parity of non-academic staff with that of IACS is found to be factually incorrect. Very, very important. Now they have recorded. I have while I was placing 178th meeting, I have indicated to your lordship that this is something which has harped upon by the group of officers. This is the paragraph. The chairman agreed. They have quoted. The chairman agreed that there should be parity between Bose IACS and Bose Institute in terms of pay structure and other benefits of the staff as indicated in the letter from Professor M.G.K. Menon, the then Secretary, Government of India. Dr. Ramasamy, in his capacity as Director DST, Government of India, informed the Council that not only should there be parity between IACS and Bose Institute, but among all autonomous institutions of the Ministry of Science and Technology. He assured the Council that such measures were already underway at the level of ministry and would be implemented with proper approval at the earliest. This is it. Now, next para. The minutes signed under the signature of Dr. Ramasamy, Chairman and Secretary of the DST, categorically states that the measure were underway and would be implemented with proper approval at the earliest. The following three conclusions may be drawn from the minutes of Dr. Ramasamy, the then Secretary DST. They are proceeding on the basis after that. There is no further deliberation by the Council. The OM number such and such dated 8th of August 1979 was not enforceable. This is the first conclusion. So, as far parity of pay and allowance of exclusive IACS and Bose Institute employees were concerned. Number two, prior approval of competent authority was required for granting parity of pay and allowances and other benefits amongst all AIs, and IACS was not having proper approval of competent authority. Now comes the next point. I'll show there is document on record that IACS has the approval from the DST direct. Next point, 16. Meanwhile, on 8th of April 2008, and all these approval that came through DST, has the knowledge of the Ministry of Finance. That I'll even show, even in regard to the IACS. Meanwhile, on 8th of April 2008, BI authorities without receipt, kindly takes this para 16. Without receipt of any approval from DST on the subject matter, proceeded with issuance of OM number such and such dated 8th April on its own. The first para of BI OM dated 8th April itself states that this fact, which is under, in anticipation of the formal approval regarding parity between Bose Institute and other similar DST-aided institution, the Director Bose Institute having been satisfied that
is the 8th April.
they have recorded from the 8th April that in anticipation, and if any otherwise decision is taken, my lord, they will be subjected to recovery.
Recovery, like
My lord, para 17. From the above, it is clear that both OM dated 8th April and 15th April were illegal and arbitrary for being issued by the BI authorities in gross violation to the prevailing GOI rule provision in utter disregard to the GC Chairman Secretary DST contained in minutes dated, utter disregard to the directions of the Governing Council Chairman Secretary DST contained in minutes dated 21st of March 2008. They say that since the Department of Science and the Governing Council, chaired by the Secretary, was taking a view, rather deliberating on the issue, so the director should not have proceeded with this. This is the stand taken by the group of officers. The usage of the phrase having been satisfied in OM dated such and such to 8th April 2008 by a subordinate authority to the Secretary smacks of act of gross insubordination. The said illegal arbitrary order were passed with clear intent of drawing higher pay and allowances and other benefit for themselves than that admissible to the corresponding employees of the central government. So, my lord, there is no whisper. They are harping on the point that 170th meeting was the last meeting where, my lord, the secretary, the chairman, were contemplating on the issue and was to come up with final decision. And there is no recording about the eventual final decision which was arrived.
171st.
So, my lord, these are my submission today as far as the implementation of the structural reform, the revised pay structure and promotion policy in the year 2008, which has illegally been set at naught by this group of officers who otherwise have no authority. My lord, I'm not making the submission considering to the authority. No. My lord, I'm just showing that even otherwise, the legality of a decision arrived at in the year 2008 cannot be questioned. You cannot go into the benefits that was drawn in terms of a duly implemented policy. You cannot go back in time and question the implementation of the 6th CPC, which was again based on the duly implemented revised pay pattern and policy. So, these exercise itself, even if assume without prejudice to my rights and contention, even if I assume that the group of officers could have gone into these questions, still, without considering the outcome of 171st meeting, can you take a considered view of the matter? But in my respectful submission, answer would be negative. This finding suffers. The finding that the 2008 policy is null and void suffers only on this ground that the main document, the principal document through which I have drawn the approval, is not even considered, though it was there before them. So, today I'll rest my submission here on these points, and on the next day, I'll start on the second limb of argument, as in the authority, the exercise of authority pursuant to 7 implementation of CPC, and how they went wrong in setting at naught the 2008 policy, and whether at all the 7 CPC benefit that they make and endeavor to rather give retrospective effect. The authority of group of officer in withdrawing the benefits with retrospective effect, can that at all be done at this juncture? But I will address your lordship on these points on the next day.
Yes.
Yeah, take over.
27.
My lords.
Argument on behalf of the petitioners heard in part. Let the matter fixed for further hearing on 27
My lords.
under the same heading.
My lord, the other matters, my lord, which Mr. Chakraborty is appearing, my lord, that also may be taken up after this, since my learned friend is continuing his argument, my lord.
Yes. Next matter. All matter. That is item number 10.
My lord.
Grateful, my lord.
Mr. Push also. Pushpal Chakraborty, my lord, is appearing for the petition. My lord.
Let the matter appear in the list on 27 under the same heading.
Grateful, my lord.
My Lordship, My Lordship, I am for the petition in this matter. My Lordship, Mr. Pushpal Chakraborty on the last occasion has sought for an adjournment for today, my Lordship. I'll be praying for an adjournment only for today.
You come on 27.
Grateful, my Lordship.
27, that is that. Call the list. Monthly list of March. Yes.
I beg to appear on behalf of the petitioner. Lordship, in earlier occasion, the state was represented, and there is a direction upon the state to submit a report. In my writ application, Lordship, my contention is very simple. That Lordship, if your Lordship come to page number 34, Lordship will find that one vacancy notification has been declared, and upon that vacancy notification, Lordship, I have applied, and this application, Lordship, is sourced from page number 34. That my application is there, Lordship, that it has been successfully applied. Now, Lordship, kindly come to page number 35, Lordship. What has been stated, Lordship, that the application has been received on 14/4/2024. Subsequently, Lordship, I paid the remuneration for that application. That is page number 36 and 37, Lordship. Now, Lordship, kindly come to page number 38, Lordship. That is the notification issued by the state government of West Bengal Department of Food Supply, Lordship, that that indicating the date on which, Lordship, they are conducting the inspection. That is on 11th June 2024, Lordship. They have that inspection will be conducted, and subsequently the inspection has been conducted, Lordship. Now I will emphasize on the point, Lordship, that during the pendency of this inspection, Lordship, they never communicate us that what is the status report of the inspection and what is the outcome of the inspection, Lordship. Now, after waiting for prolonged time, Lordship, on 17/9/2024, Lordship, I made a representation with a request, Lordship, that to follow up and expedite the issuance of the new FCS license under the vacancy issue notification such and such, Lordship. That had never been considered. And subsequently, Lordship, kindly come to page number 44, Lordship. That is the all on a certain, Lordship. What I have found, Lordship, that on online portal, it has been shown that my application has been rejected. That is on my state is there, Lordship.
Before file announcement, there was a direction to file affidavit in opposition.
Yes,
But
Your
I might delete here. My lord, kindly grant me a few days extension. It's almost ready, my lord. I could not reach day before yesterday and yesterday also to pray for time, my lord. The meantime, kindly grant us a very few short time, my lord. In the meantime, I have already prepared, my lord. I'll file and submit announcement.
And Lordship, what is my condition at this present
There are
juncture,
reasons,
Lordship, that
there are reasons, let me.
absolutely, Lordship, I am not on that. I am not opposing anything, Lordship.
No, no,
I am not
that-
opposing. What I am saying, Lordship, that during the pendency, Lordship, as my rejection has been rejected, my application has been rejected. Now, subsequently, Lordship, they will further issue a fresh notification over that particular point, Lordship. But outcome of the writ application, Lordship, the decision will be kept. The decision will be by your Lordship's order. As I have prayed, Lordship, that I may not be rejected, Lordship. There are some discrepancy and there are some foul play in their part, Lordship. That's why my application has been rejected. Now, Lordship, during pendency of the writ application, kindly, Lordship, they do not issue a fresh notification until and unless the disposition is disposed of. Only that can be passed.
Your candidature was rejected.
My candidature was rejected, Lordship.
Then-
That one, what I'm saying, Lordship, that
Yes,
one
yes,
notification has been issued. Absolutely, absolutely. I am on. What I am submitting, Lordship, whatever it will be, Lordship. My contention is very simple, Lordship. One notification has been issued. Upon that notification, I have applied for the new license. My application has been rejected. Now, the fate of this writ application, Lordship, that whether I will be eligible or not, that is the subject matter of the writ application, Lordship. That I may succeed, I may not succeed. During that pendency, Lordship, as that first notification has been already been dissolved by way of rejection, Lordship, they may issue fresh notification for the fresh applicant.
Who said that they will
Yes, sure.
apply?
That-
Maybe there are some other candidates who are
No,
eligible.
so far, my
Even so,
Why you are
go down.
supposing that they will
Lordship, if Lordship is on that view, Lordship, then let them come.
not
Let
the view.
Lordship.
You do not know whether
That
anyone
is also true, Lordship,
succeeded
that I
or
do
not.
not know that whether anyone is succeed or not.
Let them file the report.
Lordship.
And only fault of on our part is the delay of filing report. Nothing else.
No, nothing.
Minor can be
Come on Tuesday, 25,
Get food.
25.
On 25.
25. But 25.
Report without affirm.
But 2-3 days more. That's another.
25, 26.
So, Lordship, kindly grant me time till 27. Kindly take the matter on the next working day.
Because
Subject to
Monday
your
to
Lordship.
4th,
Lordship.
4th of March.
4th of
4th
March.
of March.
That will be the date of monthly.
The
No.
Learned Counsel appearing on behalf of the state authority seeks some time to file the report.
Affidavit in opposition earlier.
File the affidavit in opposition. Let the time for filing the affidavit in opposition.
I
He
do not know. My
extended-
landed friend is saying that I have no go down, Lordship. I
Till
have the go
next
down that
week.
I will show.
Till next week.
I have the go down.
Let the matter appear in the list on 4th of
If there
March.
is discrepancy in the go down, Lordship, I will say on that, Lordship.
I'm grateful, Lordship.
Lordship, in this matter, I am appearing on behalf of the respondent. Lordship, I am praying for not today.
You are appearing on behalf of private respondent.
Private respondent, actually on behalf of Mr. Ramesh Dhara.
Okay. Not today means today I am taking the group 8 matters. Now it will be appear on Monday. Monday,
Grateful.
not today.
For the petition.
Esteemed Your Lordship, I appear on behalf of the state, Your Lordship.
This is my affidavit of service. The peculiar case, my lord, why my candidature has been rejected on the ground that initially I fall ill and subsequently later I placed my case. Well, kindly turn to page 23. It's a vacancy notice dated 2nd of November 2023. Location Amarpur, Sadhukolla, near Datpur, Bagan bus stop, PS Rejinagar, Murshidabad. Need not go through the same. Kindly turn to page 27. I have submitted within time on 14th of April 2024. This is the within the stipulated time. That is page filer 27. Then must kindly come to, this is very important, page 28. Along with my application, I have submitted all the documents, including this medical certificate. You will also kindly take pain to go through the same. Medical certificate of fitness. I have examined Sri Swanso Yusuf Ali Khan, petitioner before Lordship, son of Swanso, aged about 49 years, by village Swanso, residence Reginagar, Murshidabad, State West Bengal, Prince Swanso, and certify that he is free from all deafness, defective vision, including color vision or any other infirmity, mental or physical, likely to interfere with the efficiency of her work, found and possession good health. The certificate is being given to him here for purpose of dealership. Signature of the candidate, signature of the medical officer, name of the medical officer, so-and-so, registration number, so-and-so. Medical officer, Bedganga Rural Hospital, then kindly count the note. This is a certificate of 28th of March 2024. I'm reading the note. Medical certificate granted by a qualified medical practitioner holding at least MBBS degree and registered with the Medical Council of India shall only be valid. The date of issue of the written answer should be within 1 year from the date of application. So, from 28th of March 2024 up to 28th of March 2025, it is valid. Now, kindly turn the page. Next page.
Is this the format of fitness?
Yes, medical certificate by the government hospital. That is the prescription.
Okay.
This is a medical certificate issued by the Rural Hospital medical officer.
So it is required to file with the application.
With the application. Along with other documents, these documents is required for medical fitness. Now, the next page, my lord, I have been intimated that an inquiry has been conducted on 19th of July 2024, which will appear from page number 29.
Yes.
Well, an inquiry has been conducted. If you also kindly come to physical verification of report. Name of the applicant, Yusuf Khan, petitioner before Lordship. Inquiry has been conducted on 19th of July 2024. Kindly see go down measurement. Let's first, well, is the go down measurement, two go downs, two counters. It comes around first one 470.34 and second one 102.745. It comes around 572.79 so far the go down is concerned. And so far office measurement is concerned, if we multiply 20 into 11.2, it comes to 20.04. Your Lordship knows requirement is go down 400 square foot and shop room is 200 square foot. Then all shade measurement has been given. Requirement is 100. It comes around 156 square foot. Distance from the central location, 70 meter only. Then the signature of the chief inspector. My signature is the left hand side, Yusuf Ali Khan. This is the report submitted by the inquiring person after conducting inquiry. Then I have been called for by the district level fair price shop selection committee by the notice dated 6/12/2024 at page 31. I have been called for to appear before the committee on 11th of December 2024 at 11 a.m. I will also kindly turn up on the date of inquiry. Specific statement has been given by the ADM that initially you have submitted a medical certificate. Kindly read, my lord, page 32. Addressing to the special secretary, director, joint director, and district magistrate also. I'm reading, my lord, subject, নতুন ভ্যাকেন্সিতে নিয়ম বহির্ভূতভাবে আমার আবেদন বাতিল করার বিরুদ্ধে আবেদন। মহাশয়, আমি ইউসুফ আলী খান, পিতা মৃত সোহাংশ ওদের দাঁতপুর গ্রামের একটি নতুন রেশন দোকানের বিজ্ঞাপন বেরোনোর অবধি আমি আবেদন করি। ভ্যাকেন্সি আইডি নাম্বার সোহাংশ। আমি একজন বেলডাঙ্গার এডিএম এর অফিসের স্ট্যাম্প রিপোর্টার ছিলাম। শারীরিক অসুস্থতার কারণে বাধ্য হয়ে উপার্জনের জন্য 6/9/2022 ছেলেকে লাইসেন্সটি হ্যান্ড ওভার করার জন্য আবেদন করি। ডাক্তার দেখাতে গিয়ে এবং সংসার চরিত্র গিয়ে আমার আর্থিক অবস্থা খুব খারাপ হয়ে পড়েছিল। বর্তমানে প্রচুর শারীরিক অসুস্থতার কারণে যা খরচ হয়েছিল তার এখনো আমি অনটনে ভুগছি। দীর্ঘ চিকিৎসার 1 বছর পর ডাক্তারের পরামর্শ মতো চলে ব্যায়াম করে এবং রীতিমতো ঔষধ খেয়ে সেবন করে পুরোপুরি সুস্থ আছি। নরন হসপিটালের চিকিৎসক আমার বিভিন্ন পরীক্ষা করে 28 দিন 2024 লর্ডশিপ আমার সম্পূর্ণভাবে ফেয়ার প্রাইস সব ক্লাসের জন্য শারীরিকভাবে সম্পূর্ণ সুস্থ ঘোষণা করেন। 8/8/2022 তারিখে তৎকালীন সময়ে বেলডাঙ্গা মেডিকেল অফিসার ওখানে অসুস্থতা ঘোষণা করেছিলেন এবং যথাযথ চিকিৎসা ফ্যামিলি করতে বলেছিলেন। কোথাও উনি লিখেননি যে আগামী দিনে আমি আর সুস্থ হতে পারবো না, কিন্তু দাঁতপুর বাগানপাড়ার ভ্যাকেন্সিতে আমি দায়িত্ব নিয়ে বলতে পারি আমার মতো সরকারি দপ্তরের নির্দেশনামা অনুযায়ী সব থেকে বেশি স্কোর আমার হবেই। টাঙ্গারি পরিবার থেকে কিছুদিন চূড়ান্ত তারিখে মুর্শিদাবাদ জেলার এডিএম এবং ডিস্ট্রিক্ট কন্ট্রোলার আমার ইন্টারভিউ নেন, মানে দিস দ্য ডিস্ট্রিক্ট লেভেল ফেয়ার প্রাইস অফ সিলেকশন কমিটি। সঙ্গে আমার একটি ভ্যাকেন্সিতে আবেদন করার পরিবিধি হয়। ক্যাশিয়ার বিধি মেনে আমার আবেদন বেশি হবেই। অথচ ইন্টারভিউর সময় আমি প্রথম পজিশনে থাকা সত্ত্বেও এডিএম জেনারেল আমাকে মুখের ওপর বলে দিলেন, 2 বছর আগে আপনি অসুস্থ ছিলেন এবং 2 বছর পরে আপনি সুস্থ হতে পারেন না, আপনার আবেদন রিজেক্ট করলাম। শারীরিক অসুস্থতা থেকে সুস্থ হয়ে কাজের মূল স্রোতে ফেরা কি আমার অন্যায়? আমি বিজ্ঞান থাকতে ভালো হতো, আমি বিছানায় পড়ে থাকতে ভালো হতো। শারীরিক নির্দেশ নেওয়ার জন্য পয়েন্টকে মাথায় রেখে আমার পরিশ্রম এবং সহিংস এবং ভালো স্কোর করার জন্য অতএব মহাশয় আমার নিকট রক্ষণ করে সহিংস হিসাব আমাকে সহিংস এ বিষয়ে বিবেচনা করে আমি যত পুনরায় স্বাবলম্বী হতে পারি তার ব্যবস্থা করব। Well, a specialist doctor giving a certificate which is required from the government hospital. And ADM saying, since 2 years back you were fallen ill, today it is not possible. This is my specific case.
Lordship,
So
these are
during
all verbal.
interview, they have told you that you
Yes, that I have
are
stated
not fit.
paragraph 10, page 14.
Your Lordship, no documentation, no written order passed that because of this reason you have been rejected. Whatever the
There order of
petitioner has
rejection is
written,
there. Any order
there
of
is no order of rejection, Your Lordship.
After filing
Formal
this petition, madam, from the official portal, it appears.
It has only been said rejected, Your Lordship, in a process where 10, 11 applicants are applying, Your Lordship. Only the applicant who has been who has scored highest has been given the dealership, Your Lordship.
Nothing has been
License,
done.
Your Lordship. Your Lordship, every applicant need not be given a reason for their rejection, Your Lordship. The person who scores the highest ought to be given the license, Your Lordship. This is the procedure.
I
Your
have not made out a
Your
case that license has been given to a
Your
better
Lordship,
candidate or somebody
the
else. My case
petitioner's
is that
reason is, may I
cancellation of my
submit, Your
candidature is under charge.
May I submit, Your Lordship? I didn't interrupt. Your Lordship, the case of the petitioner is only because he was ill 2 years back. That is the reason why he has been rejected. But no such order has been placed on record, Your Lordship. May I be allowed to come back with affidavits or a report on record, Your Lordship, to indicate that who has obtained the highest score and who is entitled to the license, Your Lordship? And what is the score of the petitioner?
Let my
Your
landlord file a report, my lord.
May I be allowed to file a report, Your Lordship?
Report.
Your
But
Lordship,
there
on
should be
the- on the
reason
basis
for
of-
my rejection must be there.
Lordship, reason, Your Lordship, Your
I
Lordship
understand.
will,
I understand.
Fine.
Come with the
Fine.
report.
Your Lordship will kindly
So the
consider
exercise
that
has
the person who scores the highest shall get
Okay,
the
exercise
license.
has concluded. So I am giving you a 1 week time.
Your Lordship, kindly grants me 2 weeks time, Your Lordship.
Next time.
Yes, Your Lordship.
Make it with 10 weeks, my lord. Because my understanding is that, my lord, they are going to issue the fresh vacancy notice because none of them found suitable, except myself. But on that count,
Very well. You come within 5th of March.
Yes, Your Lordship.
Okay. Having heard the learned counsel for the parties, counsel for the petitioner, and after hearing the learned counsel appearing on behalf of the state authority, it appears that the instant writ petition cannot be disposed of. Writ petition cannot be disposed of without purging the report from the state. Let the state be directed, state authority be directed to file a report. You file only report, not the
Yes,
affidavit.
report, Your Lordship.
File a report on or before 4th of March 2025. Let the matter appear in the list on 5th of March under the same heading.
but Lord, kindly mention therein that the ground for rejection of my candidature. Otherwise, my lord,
This is an absurd submission, Your Lordship.
All report will come. No issue.
All report will come. The person who
After
scores
if I-
highest and
Okay.
whatever report is there shall be
Okay,
produced, Your Lordship.
so they will enclose all the
Affidavit
reports.
of service filed on behalf of the petitioner is
A
taken.
report shall be filed, Your Lordship.
The report shall be filed,
If
enclosing there is the
Justice
report.
wants me to file
At
an
least-
affidavit in opposition, then we can deal with everything and we can.
I'm not saying so. I'm saying that the report, inquiry report, or the result must be enclosed with the report. Otherwise, I cannot know why the ground
Yes,
for
yes,
rejection.
Lordship,
everything.
We appear for the state. We cannot submit a report in the air, Your Lordship, like the petitioner can do without a
Okay,
order.
okay. I'll check at the report. No issue.
My lord, matter to appear.
I have said as the exercise has concluded, you have submit the complete report.
Matter to appear. Madam, matter to appear. কবে বললো?
Next.
My lord.
17, Your Lordship, I appear on behalf of the state, Your Lordship. I'm Nicha.
Officer Ramesh Thara, I'm praying for nothing.
Okay, come on Monday.
Monday, Your
Monday, not today.
And get close.
Not today. Yes.
My lord, I was a MR dealer. I was a MR dealer licensee for the village of Beokhali, Basudepur, and on 11/8/2023, Inspector FNS Haldia Block visited the MR dealer shop without any prior intimation. And after that, on 9/10/2023, they issued a termination by memo number such and such. And after that, I have I have prepared an appeal before the district controller, and then on 3/1/2024, I appeared before the district controller. And after
The
district controller.
yes.
And after that, the district controller imposing 3 times fine upon me. That is the case.
Then what? Take the mic. Yes. Proceed.
My lord, after that, I have sent a letter praying reducing the penalty amount, but after that, nothing hasn't happened. My lord, Annexure P10, page 36, my lord.
Page
36.
page 36.
Yes, my lord. My lord, please come to page 35. There is a calculation sheet, and here I can find that 3 times fine has been imposed upon me. And as per Rule 24, that imposition of fine is according to the gravity of the offense as per Schedule A.
So you have preferred appeal before the first appellate authority.
Yes, yes.
There are second appellate authority. Why not approach for the second appellate authority?
My lord, as there is some time boundation factor is there, because I am an ill and aged person.
When the order was passed?
My lord, order was passed on. Order was passed on 1/4/2024. Handed over to the court. I have filed a previous petition.
April 2024.
Yes, my lord.
Now you are February 2025. What is your prayer here?
I have to reduce the penalty. I have already mentioned. As I am a 60-year-old aged person and ailing person, and I have submitted all the medical papers to the district controller.
There are mismatch in your shop room.
Yes, my lord. Because of my illness, I have to maintain the shop by some shopkeepers.
Your FPS dealer or distributor? Distributor.
Yes, my lord. My lord, page 16, my lord, Annexure P1. My license. Dealer, my lord.
So you are submitting that the calculation is improper.
My lord, not improper, but the fine is 3 times, my lord. My lord, the gravity of the offense is not that such that 3 times fine has been imposed upon me. That's why I am coming before the court. Because already.
What is the provision regarding fine? Show me.
My lord, My lords, kindly come to para 24 part 2. My lord, part 2 says the licensing authority, after giving the licensee an opportunity of being heard and after recording the reasons thereof, may terminate the license or may reduce the volume of business to reduction of tagged ration cards and or impose fine according to the gravity of the offence as annexed in Schedule A. In case of imposition of fine, the licensee shall have to deposit the fine with the subdivisional controller, food and supplies through treasury challan or such and such. Entire proceeding, my lord, the imposition of fine according to the gravity of the offence as annexed in Schedule A. The last line of
So the provision of appeal is there. You prefer the appeal?
yes, after that termination was removed and a hefty fine was imposed upon me, and that is 3 times.
No, this is the provisions of FP shop. The dealers. What is the provisions for distributors?
My lord, here it is mentioned as the calculation sheet. Here is the mentioned as per Schedule A of WBPDS MNC Order 2013, and this is that. Kindly come to the calculation sheet. It is mentioned here.
So you may prefer appeal against the order before the director
Yes, my lord, but there is a time factor is
within 30 days
yes, my lord.
from the date of receipt of the order.
My lord, after receiving the after the appeal, I have to wait for 3 months for the order, and I have challenged that in a previous writ petition, and on that date, that order has been supplied to me by the state government after 3 months.
Where is the order?
My lord, the order is as page number 32, annex P9. The last page, page number 34, last paragraph. My lord, may I read?
No, that is not the that. I want the order of this court. Okay, I got it.
My lord, page 31. Page 30 and 31. 31.
Yes, you received the order. Then why you not proceeded against the appeal?
My lord, already 3 months elapsed. So that because there is a provision of 30 days.
No, on 18th April, when the order was passed by this court, you received the order copy of order.
Yes,
That
my
is
lord.
1st of April.
Yes, my lord. Yes, sir.
Then why you not preferred appeal?
But my lord, after that, I have a talk with the district controller, verbal, and after that, after a long span of time, on 11/11/2024, I have make a letter. Because over telephone, district controller told me that the penalty amount will be reduced, but that is verbally, my lord. And for that, the time has elapsed, my lord. And after that, on 11/11/2024, I have made a letter to reduce my penalty, and after that, I have come before this court.
Now, where is the provision regarding penalty amount?
My lord,
3 times penalty.
there is
3 times penalty. 3 times.
there is not the 3 times penalty, imposition of fine according to the gravity of the offense.
Gravity of the offense. What
Yes,
is the penalty provision regarding penalty, imposition of penalty?
My lord, 24(2).
Yes, I have gone through the 24(2).
My lord, last line. Tag ration cards and or impose fine according to the gravity of the offense as annexed in Schedule A.
Where is Schedule A? Get ready. Come on Monday.
My lord. My lord, schedule is. My lord.
Yes, up to maximum 3 times.
Yes, that is maximum, my lord.
So it is justified according to the law.
My
Why
lord,
are you
that is
challenging
that
this?
is maximum gravity of offense. But here the visit is surprising visit. No prior notice, nothing has been supplied to me that visit was conducted. And according to after that, everything happened.
You prefer appeal. I am giving you the opportunity. Please take down. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner is a MR shop dealer and running the business for quite long time. Petitioner is about 60 years old and suffering from several old age ailments. Full stop. The concerned inspector of SCFS suddenly inspected the shop come go down of the petitioner and served a notice come show cause notice of show cause and termination. No, কি বললাম বলো? না, petitioner and found some irregularities on the basis of same. The license of the petitioner put under suspension by supplying a copy of so cause notice on 11th of August 2023. Full stop. Petitioner has replied to the so cause. And after hearing the petitioner, the concerned SCFS has terminated the license on video order dated 9th of October 2023. Petitioner preferred an appeal against the order before the district controller. Before the first appeal before the district controller, who video order dated 1st April 2024. Has reduced the penalty from termination to imposition of fine. That is 3 times of 3 times of the So first one suspension ratio. That is value of 3 times value of food grains defalcated by the petitioner. It is the case of the petitioner that he approached the concerned district controller for reduction of such fine amount, though he was verbally assured for reduction by the district controller, but subsequently district controller has not passed any order. Accordingly, he made a representation to the district controller on November 11, 2024 for reduction of the penalty amount. The representation was not considered, hence this writ petition. Also, having heard the learned counsel for the parties, also after carefully considering the order of District Controller Food and Supply Puru Mendipur, it appears to me that the District Controller has imposed, has reduced the penalty from termination to imposition of fine. It is the view of the appellant, it is a submission of the appellant that the imposition of fine amount is the highest punishment which cannot be imposed. On perusing the Schedule A of the WPDS Control Order 2013, it appears that the authority may impose 3 times fine, 3 times on a fine amount of 3 times of defalcated food grains. Full stop. However, it appears that the petitioner is aggrieved against the imposition of fine amount. According to the provisions of clause 25, the aggrieved person against the order of district controller, food and supply may prefer an appeal before the director, DDPNS by preferring a second appeal. However, the second appeal has to be preferred within 30 days from the date of passing of the order by the district controller. It appears that I am satisfied with the ground that appellant and that the petitioner has not preferred the appeal within time. However, considering the facts and circumstances of this case, the appellant may be allowed, the petitioner may be allowed to prefer a second appeal before the director, DDPNS against the order of the district controller. Under the above observation, the instant writ petition is disposed of with a liberty to the
time frame may be given
yes
to the petitioner to file the appeal.
Yes,
to be considered in terms of in accordance with law.
Yes. With a direction to the petitioner to file a second appeal before the concerned director, DDPNS within 3 weeks. So within 3 weeks from the date of passing of this order. Within 3 weeks from the date of
already they are out of time now. They are negotiating.
Within 3 weeks from the date of passing of this order. If such appeal be framed, if such appeal be filed within the stipulated period, the limitation for filing the appeal would be condoned according to the provisions of Section 12 of Limitation Act. by the concerned authority. Full stop. The concerned authority shall dispose of the appeal according to the law after giving an opportunity of being heard to the petition. The appeal should be disposed of within 8 weeks from the date of filing of the appeal. The decision of the appeal would be intimated to the petitioner within 2 weeks thereafter. Under the above observation, the instant petition is disposed of, full stop, as since no affidavit has been exchanged, comma, the allegation made in the writ petition shall be deemed to have been not admitted. Full stop. This court has not entered into the merit of this matter. Concerned authority is at liberty to dispose of the appeal if filed according to the provisions of law without being influenced by any observation of this court. Affidavit of service filed on behalf of the petitioner is taken on record.
Grateful, Your Lordship. Appearance of the state.
Next,
Let I beg to appear on behalf of the petitioner. There is a very innocuous prayer. The person before your lordship, the petitioner, has made an application for being appointed as an FPS dealer. Now, my lord, we had the occasion of assisting your lordship and other courts also. My lord, there has been an stay granted so far as 2013 control order is concerned. So far the appointment is concerned. Now, my lord, it restricts only the appointment should not be made, but the other steps the department was, my lord, given a liberty to proceed with. Now, my lord, the petitioner before your lordship only prays that the stage should be intimated because he has made an application. He also has a right so far as knowing the status of the application. Only this much, my lord, nothing more, nothing less.
so what you want by this writ petition? What is your prayer?
Prayer is
Speedy disposal of the procedure.
That cannot be probably granted because, my lord, there is a stay and the matter is pending before the division bench. Only, my lord, up to the stage where the department has made an inspection, let be known to the petitioner. Because
inspection was done in terms of the
because
provisions of law.
Yes.
But what about the other steps?
Is other steps the state can, my lord, apprise your lordship because that other steps are not being made because
So it was you are not rejected.
No, that is where, but as they cannot probably, my lord, make any appointment. That we also appreciate because of the, my lord, stay granted by the division bench. We want that up to which, because now they are sitting tight. They are not doing any inspection. They are not doing anything.
No,
but
inspection has been done, I think.
No, nothing has been done. So let them, my lord, intimate at what stage the, my lord, the steps has been taken. Take appropriate steps immediately and update the petitioner regarding the status of appointment process. Nothing more than that, because
whether you made a representation.
My lord, an advocate's notice was sent. If your lordship directs, I can, my lord, prefer a fresh representation before the authority. A notice demanding justice. That was on 9 January 25. It was placed. And, my lord, the relevant documents annexed with the application for grant of license is also before your lordship, my lord. Those are inconsequential so far as the prayer that I am making right now.
Very well. I am passing the necessary direction to conclude the procedure, but so far as the license is concerned, that cannot be given.
Yes, my lord.
Okay. Yes.
Your Lordship, I am appearing for the state respondent. I am led by Shuman Gupta. So if Lordship kindly keep the matter in the next day because he is not present.
Requirement for keeping, I am disposing of this matter. You just take it note. Please take down. The petitioner applied for the license in terms of vacancy notification number 279 dated 16th of May 2024. It is the contention of the petitioner that he applied for the license by making proper application with proper fees. Since then, no inspection or other procedure for fill up the vacancy was conducted by the state authority. He paid for necessary order so that the state authority may be conclude the entire procedure as early as possible. First, having heard the learned the state is represented through learned counsel Mr. Sengupta. Full stop. It appears that the petitioner has filed application for grant of license in the vacancy notification in terms of vacancy notification dated 16th of May 2024. But the authority concerned has not proceeded properly according to the time frame as laid down in the West Bengal Public Distribution System WBPDS Maintenance and Control Order, WBPDS Maintenance and Control Order, MNC 2013. Full stop. Next, I am aware of the fact that there is an interim order of the Honorable Division Bench of this court in a batch of appeals being MAT 1543 of 2024, wherein the state authority was directed not to not to delink any dealer from the distributor or not to link any dealer, new dealer, full stop, not to link in new dealer, full stop. However, I make it clear that the interim order passed by the division bench in 1543 of 2024 is not has not debarred the state authority to proceed with the selection process. Considering the same, I make it considering the same, the instant writ petition is disposed of with a direction to the state authority to dispose of the selection process according to the time frame laid down in the WBPDS MNC order 2013. But so far as grant of license is concerned, that shall not be issued till the disposal of the till the order passed by the till the disposal of the batch of appeals pending before the Honorable Division Bench in MAT 1543 of 2020. Since no affidavits are exchanged, the allegation made in the writ petition shall be deemed to have been not admitted, This court has not entered into the merit of this matter. The authority concerned is to take appropriate decision according to the law without being influenced by any observation of this court.
Grateful, my lord. My lord, my lord, I forgot to give the affidavit of
Affidavit
service.
service filed on behalf of the petitioner is taken.
Grateful, my
I beg to appear on behalf of the petitioner, Lordship.
Yes.
Lordship is regarding the vacancy, Lordship. That in my area, Lordship, within the periphery of my shop room, Lordship, one vacancy notification has been issued, Lordship. Your Lordship will find the vacancy notification at page number 44.
Where is your license?
License at page number 43, Lordship. That I having lawful possession of the godown space at Pukurpara, Jadupur 2, post Mokdumpur, English Bazar, Malda. And Lordship, that the your
What is the
Lordship
subsequent license? It is valid up to 31st 12 2023.
and subsequently, Lordship, it is renewed, Lordship.
Where is the document?
That probably that has not been annexed, Lordship. This license is valid till up to
You
Lordship.
give me the slips,
Lordship.
allocations to your
Lordship.
shop room. That will suffice.
Lordship. So I will come back on Monday with
Monday.
Lordship.
On Monday with supplementary.
Lordship.
Have the documents.
I will bring the document, Lordship.
Okay, you just bring that.
Just bring the document. Get with your Lordship.
That you are running the business.
Yes.
Next.
I am for the respondent number 6. Petition came with
Yes, where is the petitioner?
making not today, my lord, because there's the impression that Monday to Tuesday that the motion is taken up.
No, list is there.
Yes,
regular
I am,
list.
my lord.
Where? Come on Monday.
Grateful, my lord.
And I am for the petition.
And for the respondents, my
Petitioner before your lordship is a retail outlet dealer
Yes.
and also carrying on the business of transporting petroleum product. And for that, your lordship kindly come to the page 19 of my work order. For transportation white oil from Haldia terminal to your petitioner's point, as also its consortium, which is situated at
Page 19 is the work order for transportation of white oil
ex Haldia terminal
ex Haldia terminal.
to your petitioner's retail outlet, as well as in the next page. Let's will get it. The details of the registered owner and his consortium, BK Kishan Porisheba,
RTO registration number WB such and such.
that is my registration number, tank truck details,
Tanker details.
tank details,
Yes.
and I have been for
Tank truck will utilize for your own loads.
I have been
Consortium
supplying petroleum products to the BK Krishna Porisheba customer code. Name of the consortium member I have also got it in the bottom, as well as in my retail outlet dealer. There is subsequent extension. Page 21 is the extension, my lord.
Name of the consortium member BK Krishna.
Yes, my lord. Which is situated at Kharagpur. I will come to that only, my lord.
Page 21
is the extension of such work.
extension of work order.
Yes, my lord. 21 is the extension of the work order. And what happened, my lord, while I was transporting the
Now,
petroleum.
what is the extension? It was extended.
Yes, my lord. It is extended, subsequently extended. Period from 1st April 2015 to 31st March 2018. Now the subject order is being extended for a period of 2 years, that is 1st April 2018 to 31st March 2020. Have you also got it, my lord?
Yes.
But what happened for the purpose of supplying petroleum product in these two retail outlets, I have to cross two toll plazas. One is at situated Debra toll plaza, and another one is at Sonapeta toll plaza. What happened, my lord? And what is there is a FASTag issued in against my tank truck, which is being issued by the Indian Oil Corporation. What happened, my lord? All on a sudden, they have deducted from my transport a huge amount. That is, you'll also kindly come to page 22. Initially deducted 2,40,274 on the ground that my tank truck has
Page
22.
Page 22. Request for clarification about the deduction from transport bill.
Yes, madam. That is my letter. They have deducted the amount. That is my letter. I sought for clarification. Now, my lord, they have supplied me the details. Next page. And from that details has not been annexed with the writ petition, which is they have supplied. From the details, you'll also I have found that at the same time, now you'll also kindly come to my legal notice. Page 40. Page 40, my legal notice. The total amount has been deducted, ultimately 5,70,059. Now you also kindly come to page 41.
Yes.
First, second, third, fourth. In this regard, it is paragraph starts with in this regard. It is pertinent to mention that for the supply for supplying MS and HN to petrol pump, no toll plaza is required to be crossed except Sonapeta toll plaza and Debra toll plaza. However, it is surprising to note that you have handed over a toll statement, but from it appears that my client said TT have crossed the different toll on different date, even in a single date within a period of almost an hour. My client city has crossed Sirampur toll plaza at Odisha and the Mohuban toll plaza at Uttar Pradesh, though the distance between the toll plaza is about 1439 kilometers. Next, I will also kindly come to the next one. I further inform that my TT, my tank truck is holding on the Bengal permit. As such, it is next to impossible on my part of my client TT to cross the toll plaza of Uttar Pradesh and Odisha. However, in the arbitrary administration, I further inform that upon a perusal of the toll statement, it has been handed over my client to. It is apparent that on 15th May 2007, at about 5:19 hours in the morning, my lord, 5:19 hours, TT has allegedly crossed the toll plaza of Billiard as well as the same time, that same date, crossed the toll plaza of Mohuban plaza. The distance between the toll plaza is 1080 kilometers. Next is also the same, my lord. I have made a detailed legal notice, and neither has been responded to by the oil company, nor they have handed over, they have reimbursed the amount which has been deducted from my transport bill. Now, since nothing has been done, I have page 47, I have made another notice to the Indian Oil Corporation on 3rd December 2023. That has also not been considered. Let them first know what is the reason for deduction of such kind of toll. You will also kindly come to page 47. Details I have given. First, second, third, fourth paragraph. Thus, from your records, have your lordship got it, madam? On 17 June 2009, our vehicle traveled 1020 kilometers from Beliard, Jharkhand to Sigda, Rajasthan, only 37 seconds, within 37 seconds. Next, time has also been mentioned. Next, on 6th October 2000, our vehicle is a distance traveled a distance of 312 kilometers from Benajoli toll plaza, Odisha to Beliard toll plaza, Jharkhand, within 1 hour 34 minutes. On a 28/11/2007 on and such an intervening night, our vehicle traveled the distance 1431 from the Bakskoda toll plaza at West Bengal to Sonapeta, Somna toll plaza, UP, which is within just 5 hours 44 seconds. This is the details I have stated according to their statement, but that has not been responded yet. What is the reason for deduction of such huge amount of toll deduction from my transport bill?
Now you are here for the representation.
Well, let them consider it or let them respond. What is the reason?
Okay.
I don't know what is the reason.
Yes.
My lord, my instruction is to file the affidavit in opposition because, my lord, my client has to check his record also, and this is a very old case, 2019 matter, my lord. Thereafter, I am praying for your lordship to allow me to file opposition, lordship.
What is the purpose for filing opposition? Whether this court can deal with these issues, whether this, how he was plied the track tanker was plied, and what is the how the toll that is the fast track tag.
Fast tag issued by the Indian Oil Corporation for my truck.
IOC
Yes,
issued the tag.
Yes. And
let-
statement, they have also
let
get the
decide
statement.
the representation by passing a reasoned order.
But treat this representation be representation. I have given the details. In representation as well, the other details.
Then you serve the representation.
I will serve.
Serve the writ.
Yes.
Okay, I am disposing of the matter.
Kindly allow me to file opposition for a
What would be the purpose for filing opposition?
I have to check the all details and all records, my
You
lord.
have already, they have already supplied you in the year 2023, everything.
They have supplied the report.
Everything is there. He is roaming before your door time and again.
But in 2018, they have supplied me the details.
I understand that you may have some defenses there.
Lordship.
But whether this court can check it out, again it has to be delegated to you, your authority to decide what is the correctness and what is the. If you want, I can give you 1 week to file the report.
Let them file the report.
1 week,
1 week?
3 weeks,
3 weeks is not possible. 3 weeks,
kindly 3 weeks.
long time. Okay, please take. Please take down. Having heard the learned counsel for the parties and considering the submission of the respondent authority who intends to use an affidavit, I think it necessary to hold that this matter cannot be disposed of without affording opportunity of the respondent authority to file an affidavit. Let the affidavit be filed within 2 weeks. Reply, if any, by the petitioner within 1 week thereafter. Let the matter appear in the list under the same heading on 17th of March.
As you wish.
17th of March.
Fine.
Related to the 18th lordship.
18th, no issue. 18th.
Grateful, my lord.
Affidavit of service filed on the division.
Okay.
Yes.
My lord, your lordship's hearing, my lord, AP 698 of 2016. That is, my lord, the section 34 application filed, my lord, by my client.
Yes.
Now, my lord, I am, my lord, in reply. अब बैठिए जी, नर्वस कर रहे हैं हम. अब बैठिए नहीं तो हम नर्वस हो रहे. My lord, there were really, my lord, I'll be very brief, my lord, because I'm in reply. Whatever I've submitted, my lord, is at the commencement itself. My lord, one session I had made my submissions. I'll just do a quick, my lord, roundup. My lord, the challenges, as your lordship knows, are two, my lord, 4, my lord, claims which have been allowed against me. My lord, the first relates to, my lord, license fees for the entire lock-in period, that is 11th August 2008 to 31st July 2013.
Yes.
My lord, 13 crores, my lord, have been, my lord, allowed, my lord, in this regard.
Yes.
Our contention was that this cannot be the case. At the highest, it could be from 11th August 2008 to 31st March 2012. And, my lord, our case is an excess amount of rupees 4.30 crores approximately has been, my lord, awarded. My lord, on this count. Second, my lord, was that, my lord, 50,000 has been awarded on account of loss of interest on security deposits that's received by my client from those to whom, my lord, it had been, my lord, leased out. And, my lord, oh, sorry, not 50,000, 50 lakhs, I'm sorry. And, my lord, 3 crores, 95 lakhs, 50,500. My lord, loss of income on account of additional license fee.
Yes.
My lord, this was so totaling to 4 crores, 45 lakhs, 50,500.
Yes.
And, my lord, which is, my lord, according to us, my lord, contrary to the contract. Then, my lord, electricity charges of 14 lakhs 68,762 and water charges for 11 lakhs 70,000.
Yes.
Which, my lord, were, my lord, awarded against us. Then, my lord, there was this as far as the claims which have been allowed against, my lord, my client. As far as my counterclaim is concerned, my lord, there has been a rejection on 2 heads. The cost of diesel incurred by, my lord, my client, which is 3.30 crores, and the cost wasted on infrastructure, which is 21 crores.
Yes.
Now, my lord, this is, my lord, the, my lord, basis of, my lord, my section 34. Now, as far as the license fee period is concerned, my lord, our case was that, my lord, the arbitral tribunal having held that possession had been made over. My lord, rightly or wrongly is a different matter, my lord. I'm not going into appeal. This is the finding, my lord, in, my lord, the award. My lord, on, my lord, 31st of March 2012, my lord, from, my lord, 1st of, my lord, in effect, my lord, 2012, my lord, this is, my lord, evident, my lord, from the letter of 12th of April 2012. And, my lord, the claimant having accepted, my lord, my termination, which was, my lord, on October 31, 2011, and, my lord, got the benefit of all sub-licensees under me, my lord, the direct arrangement, my lord, of, my lord, receiving payment for them. My lord, they had not suffered any damage, my lord, from the period 1st April 2012 to, my lord, the, my lord, period 31st of July 2013. That's the lock-in period. Now, my lord, my challenge to this was that having come to these foundation, my lord, factual findings.
Yes.
My lord, even if there is a lock-in period, and my lord, the agreement says this is the amount to be paid. My lord, unless they prove damages, they cannot claim this. And that is, my lord, Kailash Nath's case, lead case, my lord, of the Supreme Court. My lord, construing, my lord, section 73 and 74, my lord, of the Contract Act. My lord, that this cannot be done. And in respect of lock-in period itself, I cited a judgment, my lord, of the Bombay High Court, my lord, of Justice Dhanuka, my lord, which was, my lord, of 29 July 2016. My lord, the cost title is Autocraft Engineers versus Akshar Mobiles.
Autocraft.
Which categorically recognizes this, my lord, for lock-in period. So, my lord, here is, my lord, the claimant who has during this period, my lord, which is, my lord, 1st of April 2000 and 1st of April 2012 to, my lord, July, my lord, 31st July 2013, my lord, not having suffered any damage. There's no proof of damage.
So Kailash Nath said unless there is a proof of damage, you
Can
cannot claim.
correct. Now, my lord, and that is, my lord, applied squarely, my lord, for, my lord, lock-in period, my lord, in leases in the Bombay High Court judgment. In fact, my lord, there was evidence on record to show, my lord, that he in fact received, my lord, to his benefit, I say, not necessarily by him, but, my lord, the, my lord, association members, my lord, ensured, who were sub-licensees, my lord, sub-licensees under me, who had paid, my lord, their, my lord, amounts, my lord, which they were to pay me, my lord, to, my lord, the bankers of, my lord, the claimant, and, my lord, he got the benefit of it. That's the finding in the award.
Yes.
And now, my lord, most important is my learned friend here, my lord, has not quarreled with the proposition of law that, my lord, damages have to be established. Then there is no proof of damages. My learned friend's, my lord, argument in law is, no, there is a formula provided in the agreement. On that basis, I have claimed damages. That's not good enough. Because here, my lord, is not a situation where damages cannot be proved. Where, my lord, a case has to be made out that it's a genuine pre-estimate of damages. That is not the case run and cannot be. Because, my lord, property, my lord, has a market.
Yes.
Property has a market, my lord, damages can always be proved. No damage proved. Instead, he's received money to his credit. That's the evidence, that's the finding, my lord, in the award. So, my lord, in my respectful submission, my lord, if the arbitral award is contrary to a Supreme Court decision, then, my lord, associate says, and so does Sanyong, my lord, it's bad. It's not only bad, it's incurably bad. It's one of the grounds, my lord, under section 34(2)(b). The fundamental policy, my lord, of Indian law. My lord, your lordship's aware, my lord, 34(b)(2), my lord, says, my lord, it's conflict with public policy of India, and the explanation to, my lord, it is in contravention with fundamental policy of Indian law. My lord, if there is, my lord, a superior court decision, my lord, on this, then, and, my lord, the award is contrary to that, Now, my lord, the most important fact is, my lord, whether I am right, whether he received money, didn't receive money, my lord, there is no finding by the arbitral tribunal that he has suffered this damage. No damages on this count was proved before the arbitral tribunal.
No finding is there.
No finding that he has suffered damage. Merely because it's in the lock-in period, it's been awarded. Rather, the award, my lord, to the contrary shows that, my lord, he has received to his benefit payments made by my sub-licensees under an arrangement, which arrangement he has accepted.
Yes.
So, my lord, very simply put, my lord, there is no evidence on record to suggest this, that he suffered damage. Second, my lord, merely, my lord, having a lock-in period does not mean you are entitled to payment under it without proving damage. And third, my lord, contrary to Supreme Court decision. So, my lord, this, my lord, in my respectful submission, my lord, is sufficient, my lord, for setting aside, my lord, this, my lord, award to the extent that it relates to, my lord, the license fee awarded for the entire lock-in period. Now, the second, my lord.
Yes.
The second bit, my lord, of, my lord, the, my lord, award, my lord, which I had challenged, the claims, my lord, it's 50 lakhs and, my lord, 3 crores 95 lakhs 50,500. My lord, the agreements are before your lordships. My lord, one is, my lord, the main agreement, my lord, which is, my lord, 30th July 2007.
Ma'am, agreement. Agreement. First problem. Agreement.
My lord, the main agreement, my lord, compilation 2, page 274, my lord, is the agreement. And, my lord, the supplementary agreement is, my lord, volume 8, page 1161. Acta volume 2, Acta volume 8. Volume 2 holo, page 274. Now, my lord, kindly take clause 17 of that, my lord, which is at page 283. My lord, volume 2.
283.
Yes. Clause 17, my lord. My lord, it is agreed between the parties that sublicense granted hereunder is personal to the sublicensee, and sublicensee shall not be entitled to transfer, assign, or in any other manner alienate its right interest created hereunder, or relet, sublet, underlet, or part with possession of scheduled premises or any part or portion thereof, nor shall allow any third party or person to use or occupy. Notwithstanding the above, sublicensee shall be entitled to assign the rights available to it under the agreement to its group companies only. So there was a restriction. Now, my lord, the supplementary agreement, my lord, which was, my lord, executed, my lord, that was, my lord, that's in volume 8. My lord, it's dated 14 June 2008. Page 1161. My lord, my argument was very simple. My lord, we are, my lord, in an arbitration, my lord, 34. My lord, this has been awarded, my lord, dehors the contract. There is no provision, my lord, in the contract for passing on, my lord, either license fee or, my lord, additional security deposit, my lord, to, my lord, the claimant. Now look at clause 17, my lord, which is amended, 1161. Lordship has that, my lord? 1161. Kindly come to 11664. 1164 at the top. Thereby the altered modified clause 17 of the agreement shall now read as follows. It is agreed between the parties herein that subject to prior intimation to the licensee, only intimation, sub-licensor shall be entitled to further sublease, assign its rights or part thereof by way of sublicensing the scheduled premises or part subject to a maximum of 30% of total space sublicensed to second party to any third parties, and thereby allowing such third party to use and occupy scheduled premises or parts as the case may be for the purpose of running, operating retail stores only. So 30% can be given, my lord, just by intimation and for, my lord, running the space. Now, my lord, there is no provision anywhere, my lord, of, my lord, any additional security, my lord, being given, my lord, by reason of sublicensing, my lord, to, my lord, the claimant, or, my lord, the license fee that I receive, my lord, from, my lord, my sub-licensees.
Yes.
Now, my lord, what the arbitral tribunal did was, in spite of two written agreements being there, relied on, my lord, oral evidence. My lord, I don't need to tell your lordships, my lord, under, my lord, the Evidence Act, my lord, the new sections I, my lord, cannot remember, my lord, 91 onwards,
Yes.
my lord, there is no question of giving evidence, my lord, contrary to an agreement. And that's, my lord, the oral, my lord, evidence. Now, my lord, here, section 91, 92, my lord, of, my lord, the Evidence Act, and, my lord, oral, my lord, evidence is relied on, my lord, which is at volume 9, 1. I've, my lord, placed it all. This itself, my lord, award beyond contract is also illegal. That is, my lord, again associated, Sangyong and Indian Oil, my lord, which I had cited. Indian Oil. My lord, 2022 4 SCC 463. That's, my lord, beyond, my lord, the contract. I'd given it in Indian Oil 2022 4 SCC 463. पहले बार दिए थे, not reciting the cases. Then come, I have it. Lordship has the cases, my lord, I had given. Now, my lord, the third, my lord, was, my lord, electricity charges, my lord, 14,68,762.
Yes.
And, my lord, water charges, 11,70,000. My lord, here again, my lord, it is recognized, my lord, that these are not claims arising out of the contracts, written agreements.
Quasi contract.
Correct. And, my lord, so this was, my lord, the case, my lord, which I had, and, my lord, even with regard to the counterclaim. Huh? Yes. My lord, cost of diesel, my lord, your lordship will find. My lord, I had made this submission. My lord, the arbitral tribunal held I have a plausible case, but didn't give me an award. Having found. So, my lord, the relief itself is contrary, my lord, to, my lord, that the analysis and reasoning. My lord, it's like, my lord, in an eviction suit, my lord, reasonable requirement case is made out. The finding is made out, but decree is not for eviction. But suit is dismissed. It's like that. My lord, I've made out a plausible case, but, my lord, it's not allowed.
Yes.
And on cost of infrastructure, did you press it? And, my lord, cost of infrastructure, I had said I'm not really pressing it before your lordship.
Yes.
So, my lord, this was the, now my learned friend, my lord, has, my lord, all credit to him, my lord, his tenacity. My lord, I've, instead of calling him just a friend, my lord, I have resorted to calling him learned friend, my lord, because he, my lord, always comes, my lord, more than ready, my lord.
Yes.
My lord, he has, my lord, over, my lord, 15, my lord, hearing sessions, my lord, cited, my lord, a fair amount, my lord, of decisions and gone into, my lord, the, my lord, evidence, my lord, which is. Now, my lord, the one thing I want to make clear, my lord, just kindly have a look at the act once, my lord. Just the act, cases I've cited, and we'll give a short, my lord, note also to your lordship.
Yes.
My lord, kindly just take section 34.
Arbitration concept.
The lordship doesn't have an arbitration act. I'll give a copy. My lord, kindly take, my lord, section 34.
Yes.
My lord, kindly come to subsection 2. An arbitral award may be set aside by the court only if, now kindly come to A, these are only ifs, etc. B, my lord, is the court finds that, my lord, kindly come to 2, arbitral award is in conflict with the public policy of India. Then, my lord, explanation is very important. For the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India when only if. Then, my lord, kindly see 2. It is in contravention with the fundamental policy of Indian law. My lord, this is what I base my submissions on also. Now, my lord, kindly see explanation 2. For the avoidance of doubt, the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. So, my lord, on the face of it, one has to show. My learned friend now can't argue, oh, this finding of the arbitral tribunal is wrong, etc., etc. Material was before the arbitral tribunal. Now, my lord, 2A is very important. My lord, both parties are Indian. So, my lord, it's a domestic arbitration. Kindly see. An arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. So even the illegality has to appear on the face. Now kindly see the proviso. This is very important. Provided that an award shall not be set aside merely on the ground of an erroneous application of the law, so interpretation of statute, or by reappreciation of evidence. There's no scope. Otherwise, my lord, arbitration, my lord, will multiply proceedings. It's supposed to, my lord, bring to an end, my lord, commercial disputes quickly.
Yes.
My lord, that's the purpose, my lord, of this act. Now, my learned friend, my lord, has, my lord, gone into, my lord, questions, my lord, of fraud. My lord, those are in his 34. Let him, my lord, argue that in his 34. Here, my lord, as far as we are concerned, and he's not saying that there is fraud, my lord, in the award made against me. My lord, if he's doing that, my lord, it can go. If he says even the award against me is fraudulent, that should go. That's, my lord, can only be an argument, my lord, as far as what he's been denied. And I am not for a moment saying, my lord, there's any fraud.
Yes.
My lord, this was, my lord, everybody was given, my lord, a fair hearing. My lord, whatever materials were on record, my lord, were, my lord, dealt with. And, my lord, an award has been passed. There's no question of any reappreciation of evidence here to sustain an award, my lord, made in his favor. You can't say, oh, this might on the face of it look wrong, but there were other factors. Sorry, it cannot be looked into. Because, my lord, there is not a fraud. He can't assail what has been given to me, given against me as fraud. If he does, kindly set it aside. I don't have to argue at all. Now, my lord, the cases. My lord, my learned friend has cited. I'll very quickly, my lord, rely on them. My lord, 2018 9 Supreme Court cases page 49, my lord, that was, my lord, relied on, that's MK Global's case, my lord, to produce documents, new documents, to justify his case. Now, my lord, kindly have a look at the act again. Let me explain it with the act. Where is the 2019 amendment? Yes. Now, my lord, kindly have a look at 34(2)(a). An arbitral award may be set aside by the court only if the party making the application.
Yes.
Now, my lord, there was an amendment on 30th August 2019. The lordship has, my lord, the pre-amended situation, my lord, in the footnote.
Yes.
My lord, earlier it was furnishes proof that by the Arbitration and Conciliation Amendment Act 2019, etc. This now, my lord, so my lord, then parties could come up, my lord, and hand over that this is the proof to decide what, my lord, an objection under 34(2)(a), a challenge, my lord, under 34(2)(a). Because, my lord, I'll give your lordship an example. It could be seen, my lord, that at the time, my lord, one of the parties was a minor. And, my lord, could not have, my lord, entered into the agreement. But before the arbitral tribunal, there was no such record. So he furnishes proof. Party was under some incapacity.
Yes.
So it was to enable, my lord, those kind of situations. This got amended, my lord, then. An arbitral award may be set aside by the court only if the party making the application establishes on the basis of the records of the arbitral tribunal that. So, my lord, it has to be found in the records of the arbitral tribunal.
This is on the basis of the record.
Correct. From furnishing of proof, it got changed to. Now, my lord, when it was furnishing proof, was, my lord, the situation where, my lord, global MK, my lord, was relied on. Now, my lord, most important is,
yes,
my lord, MK Global permits, my lord, here also, my lord, the award will be governed by the pre-amendment. So, my lord, documents can be brought in to the court. But for what? Now, kindly see what, my lord, MK Global says. My lord, my lord, other side had given, my lord, a copy, 2018 9 SEC 49. MK Global. You relied on it. You relied on it. It's there. Huh? My lord, 8 new documents were produced by relying on it. My lord, this is, my lord, the copy my learned friend relied on. এরম দেখতে, এরম দেখতে। একটু আলাদা দেখতে, সেই জন্য বলছি। খালি তা নয়, এইভাবে আছে। আমাকে দিন, আমি বার করে দিচ্ছি 1 মিনিটে। জজ সাহেব মার্ক করে থাকবেন। ওইটাই, ওটা নয়।
89 SCs. 14.
এটা দিয়ে দিন, তাড়াতাড়ি হবে, খুঁজে বার করতে করতে আপনার। My lord, my learned friend relied on, my lord, this, my lord, not from the true SCC print. So, my lord, I am giving your lordship exactly, my lord. My lord, this is what was given to us. My lord, kindly, my lord, ওইটা দিয়ে দিন, তাহলে সুবিধা। This is relied on by them.
Yes.
Now, my lord, kindly come to para 22. এই জন্য বললাম একটু আলাদা দেখতে। Para 22. It will thus be seen. My lord, the short point is MK Global only permits before the amendment, my lord, documents which are necessary in the rarest of rare cases only for 34(2)A. It doesn't relate to 34(2)B. Kindly have a look.
That is the furnishes proof that.
Yes.
This portion.
Oh, yes. So, my lord, furnish
Amended.
and 34(2), my lord, if the court finds, it has to find from the records. My lord, and my lord, Supreme Court makes it clear, my lord, this is Justice Nariman's judgment. My lord, Justice Nariman was sitting, my lord, with Justice Indu Malhotra when this judgment was passed. Kindly see. It will thus be seen that speedy resolution of arbitral disputes has been the reason for enacting the 1996 Act and continues to be the reason for adding amendments to the said Act to strengthen the aforesaid object. Quite obviously, if issues are to be framed and oral evidence taken in a summary proceeding under 34, this object will be defeated. It is also on the cards that if bill so-and-so is passed, then evidence at the stage of 34 will be dispensed with altogether. Given the current state of the law, we are of the view that the two early Delhi High Court judgments cited by us here and above correctly reflect the position in law as to furnishing proof under section 34(2)A. So does the Calcutta High Court judgment. We may hasten to add that if the procedure followed by Punjab and Haryana High Court judgment is to be adhered to, the time limit of 1 year would only be observed in most cases in the breach. We therefore overrule the said decision. We are constrained to observe that FISA developers was a step in the right direction, as its ultimate ratio is that issues need not be struck at the stage of hearing a 34, which is a summary procedure. However, this judgment must now be read in the light of the amendment made in so-and-so. So read, we clarify the legal position by stating that this is before the amendment, they're clarified. We clarify the legal position by stating that an application for setting aside an arbitral award will not ordinarily require anything beyond the record that was before the arbitrator. However, if there are matters not contained in such record and, now mark this, and are relevant to the determination of issues arising under 34(2)A, they may be brought to the notice of the court by way of affidavits filed by both parties. Cross-examination of us should not be allowed unless absolute as truth will emerge on a reading of affidavit. Therefore, set aside the judgment. So, my lord, the law prior to the amendment, my lord, was, yes, you can rely on additional documents if absolutely necessary, but and which are not in the tribunal, the records of the tribunal, but only for 34(2)A.
34(2)A.
My lord, here the challenge, my lord, in my section 34,
Yes,
is, my lord, on 34(2)B. So, my lord, whatever, my lord, has been relied on, my lord, cannot, my lord, be relied on at all. And this was the decision cited to, my lord, rely on additional documents. So I'm not dealing with any of the additional documents because this is the Supreme Court, my lord, which is clear on it. It's nobody's case that, my lord, I am seeking to establish grounds under 34(2)A. And in any event, my lord, this is available to the person alleging, my lord, 34(2)A. So, my lord, I could have, if I had invoked 34(2)A, not him in my application.
yes.
If I'm not wrong, this judgment was, I was to cite, I was denied. Mr. Medora objected to that. I wanted to file an additional documents by way of an affidavit. Your Lordship also suggested this you can do, Mr. Surana, in your application, not in this application. So this judgment was not cited by me.
Why are you saying it was cited? My lord, we have the copy he gave
Yes,
us. Now, my lord, my learned friend has, my lord, and my lord, I point this out, subject to correction, your lordships will correct me. My lord, Justice Dhanuka's judgment, my lord, that autograph judgment which I relied on, lordship seen it in your lordship's note itself, my lord, today when I started.
Yes.
My lord, has not been dealt with by my learned friend, which is squarely, my lord, covered. My past arguments which your lordship noted has, my lord, autocraft's case mentioned in it.
Autograph.
Yes.
Regarding lock-in period.
Correct. That has not been dealt with by my learned friend. At least my juniors haven't. I, of course, wasn't there, my lord, so I would not have. That's why I said subject to correction by your lordships. Now, my lord, my learned friend has relied on Mitesh Mehta, my lord, versus Saregama. Is that correct? Now, my lord, my learned friend, my lord, has relied on Karyapet's case. Am I correct? 61 Calcutta. Karyapet. You relied on it or no? But Karyapet you've not. Huh. Now, my lord, yes. Now, my lord, what is important, my lord, is both these cases, my lord, relate to civil suits in the High Court. My lord, Karyapet's was, my lord, a leading case which your lordship's aware that, my lord, the witness has to be put in cross-examination, my lord, suggestions as to, my lord, the case, my lord, of the other side.
Yes.
Otherwise, my lord, it will be proceeded on the basis that's been given up. This is a classic case. In arbitration, we don't need to do that because the Evidence Act doesn't apply. Second, my lord, Mitesh Mehta's case, my lord, where I had the privilege to argue, my lord, for my lord Saregama, related to infringement of copyright. Again, my lord, in a civil suit. So, my lord, they really have, my lord, no, my lord, application at all. Now, my lord, decisions have been relied on. My lord, Bhagwati Prasad versus Chandramal, 66 Supreme Court, Sham Cell, Bahubali Promoters, and my lord, Suman Rai's case. My lord, these are all on, my lord, mean profits. Not relevant for mine at all. Because, my lord, my 34 doesn't involve mean profits at all. If he has to rely on it, my lord, maybe in his 34, my lord, if he has to place, my lord, any, my lord, case on this. Then, my lord, group companies doctrine.
Yes.
My lord, 5 cases, my lord, were relied on. My lord, that, my lord, in group companies, my lord, doctrine, my lord, a person who is not, my lord, an EO nominee, my lord, party to, my lord, an arbitration agreement. My lord, if the intention, my lord, was also to bind, my lord, group companies, then, my lord, an arbitration could proceed against them. My lord, it's wholly irrelevant in my 34. My lord, I am saying what's been awarded to me and what has been denied to me is what I'm challenging. My lord, again, my lord, with the greatest of respect, my lord, these, my lord, of course, my lord, they might, my lord, he might rely on it to, my lord, rope in everybody in his 34. But, my lord, in my 34, my lord, this can have no application. Then, my lord, my learned friend relied on, my lord, several decisions. My lord, on section 34, my lord, I don't have, my lord, any, my lord, grievance, but my lord, after, my lord, Sangyong, my lord, for, my lord, domestic arbitrations, my lord, we are governed by Sangyong, and, my lord, to the extent Sangyong says of associated. And all cases, my lord, thereafter have, my lord, trodden the same path. So, my lord, to the extent, my lord, any of these cases which my learned friend has relied on is, my lord, pre-Sangyong, then, my lord, is of no use at all. And lastly, my lord, my learned friend talked about suppression. My lord, that, my lord, orders obtained through fraud or suppression can be set aside anytime, even if a mistake is made by court. My lord, he could look at, my lord, his 34 to rely on all these. My lord, if he says that this should apply to mine, to, my lord, have the award made in my favor set aside, I have no problem. And, my lord, several decisions have been cited, my lord, under the old act, my lord, old Arbitration Act. I'll make a list of them. Really, my lord, has no application now, my lord, after, my lord, 34, my lord, in this, my lord, 2013 Act. My lord, those are my submissions, my lord. I give a very short note to your lordships, my lord. Few pages only. And your lordship limits the number of pages so that, my lord, no party can give your lordships, my lord, another 5 volumes to read. If your lordship says 1 page, I'll do it in 1 page. Thank you. You give it, I'll write your notes.
Number 1. Argument on behalf of the party is concluded. Made CAV. Parties are at leave to place written notes of argument, concise form of written notes of argument within 2 weeks. Within 2 weeks.
My lord, kindly limit the number of pages, my lord. Kindly. Make it 15 if your lordship has to. My lord, because my learned friend will be giving, but don't make it, my lord. My lord, my idea of concise, my lord, for a hearing is maximum, my lord, 5 pages.
Okay. Parties are at leave to file written notes of argument in concise form, most preferably within 5 pages.
Obliged, sir.
Bracket close. Most preferably within 5 pages. Bracket close. Within 2 weeks.
Obliged.
From date. Yes.
May I be allowed to make a short reply on this tomorrow, my lord? Just a short reply.
No, my lord, there can't be reply to reply. I have not cited any new cases. My learned friend can start his 34, my lord. I'd love to hear his 34.
Yes, the written notes of argument.
Yes.
Within 2 weeks. Within 2 weeks. The matter appear under the heading of 2 months on 2 weeks. 2 weeks. 2 weeks. 2 weeks. 7th of March.
Obliged.
7th of March. Okay, call the matter.
But a small request.
Yes.
As I have mentioned earlier, that let there be a direction on the learned registrar for collection of that 12 lakhs from the banks. And
I have directed to file an application.
I have made out an application, but unfortunately, in the records, it is shown that there is some other arbitrator sorry, other advocate on record, though I have already submitted no objection, but it is not appearing in the record, so that application was not considered.
Have you served the copy upon them?
No, unless it is affirmed, I cannot serve them.
Huh? Hmm. 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 Leave granted. Okay, leave granted to file applications. You file the copy of applications to them. Okay. Okay, leave granted. Okay, okay. On the next matter.
I'm for the petitioner.
Yes.
The last occasion was well, I have started my argument on behalf of the respondent on the last occasion. I have submitted I have submitted the gist of my argument. Now today I will show the documents in support of my argument. The first point that I took, my lord, this is if this may be treated as a third appellate step. First, there was a show cause proceedings. A show cause notice was given. A reply to the show cause was given. Thereafter, a hearing was conducted and a reason order was passed by the authority, the first authority. So that was the first stage. Thereafter, against that order, an appeal was filed before the appellate authority. Then, before the appellate authority also, there is after the appellate authority decided and passed an order. Thereafter, this is the third round of litigation, like the third stage, as I said, the writ petition. Now, my first point was that the petitioner cannot be permitted to improve his case at this stage. The case which the petitioner has made out in the show cause proceedings, the petitioner should not be permitted to improve his case.
First time at the writ stage.
Right.
Yes.
I will deal with the merits of his argument, which is he has taken in the appellate in the writ petition. I will definitely deal with that. But my primary objection is that contention cannot be the petitioner should not be permitted to argue to take that case to make out that case in the writ petition at the first time, because he has not made out that particular case when he was given the opportunity in the show cause proceedings. Now, my lord, kindly now may I place the reply for
the reply to the show cause.
Now, kindly seize the show cause ones. Show cause is at page 83. The writ petition. show cause was given on 25th of July 2023 at page 83 of the writ petition.
Yes.
Now kindly see, may I place the show cause, my lord. This has reference to the inspection done by QRC officials on 14th July 2023. Copy of the inspection report is enclosed. So along with this show cause, the inspection report was also provided for the petitioner to deal with the report. The following discrepancies were observed in the functioning of your distributorship during the subject inspection. Now the first discrepancy. More than 25% of the filled LPG cylinders loaded in a delivery vehicle for delivery to customers found underweight beyond permissible limit prescribed in the Legal Metrology Pact Commodities Rules 2011. So here the rules has been specifically referred. The rules on which the petitioner is now relying upon, that rules was not followed. That rule has been specifically referred in the first charge. MDG clause, not only that, as well as MDG clause number 1.2.2. Now, what were the discrepancies? The details were given. En route SQC was conducted. Now, kindly sees en route XQC, which is en route. It's not referring to the godown inspection carried out at the godown or the inspection carried out at the showroom, showroom. It refers to the inspection which was carried out on the route, en route. Yes. In the distributors, 2 delivery vans, 2 numbers, 10 numbers, 14.2 kg cylinders in each van. Van number 1, name of the delivery boy and vehicle number Nandkishore Singh, number of filled cylinders in the vehicle 10 numbers of 14.2 kg, number of the filled cylinders found underweight beyond permissible limit 4 numbers 14.2 kg. Then van number 2, name of the delivery boy Radhesham Mahato, number of filled cylinders in the vehicle 10 numbers 14.2 kg, numbers of filled cylinders found underweight beyond permissible limit 2 numbers 14.2 kg. Total number of filled cylinders found underweight beyond permissible limit for 20 numbers filled 14.2 kg cylinders are 4 plus 2 equal to 6 numbers of 14.2 kg, that is 30%, and the permissible limit is it can be more than 25%. Within bracket it has been mentioned which is more than 25%. Then now this is the first discrepancy which was pointed out.
Yes.
Underweight of the number of cylinders. Details of the cylinders as well as the delivery boy as well as the delivery van, everything has been given. Now the second point, the second discrepancy. Shortage of more than 50 domestic cylinders or domestic pressure regulators or both put together detected during the inspection or in the date of inspection MDG. Now, first one as I referred, first one discrepancy is in respect of the en route inspection. Second one is in respect of the shop room.
Storage.
Shop room and godown.
Shortage from more than 50% 50 domestic LPG cylinder.
Right. So the shortage is at the godown.
Godown.
So point number 2 is for the godown inspection which was carried out at the godown.
Yes.
14.2 kg filled cylinders found 40 numbers and empty 14.2 kg cylinders found 227 plus 1 showroom numbers in the physical stock. So there was a variation in the physical stock physical stock with the manuals like the registers.
As per stock book.
As per stock book, minus 31 numbers 14.2 kg filled and 1100 numbers 14.2 kg empty cylinders were observed. Hence, unaccounted sales observed in filled 14.2 kg cylinders is 31 plus 407, that is 438 numbers, and 1100 minus 228, that is 8 872 numbers of empty 14.2 kg cylinders. Excess observed in field 14.2 kg cylinders in 438 numbers, and shortage observed in empty 14.2 kg cylinders is 872 numbers. So there has been a variation found in the stock registers with the physical stock.
Yes.
Now the details of the cylinders were given. Now the third discrepancy. Unaccounted sale of more than 50 filled cylinders in 14.2 kg and 5 kg supplied OMCs at subsidized and non-subsidized domestic LPG rates detected during the inspection on the date of inspection. And the violation is 4.2 MDG clause given 2.1.5.
Unaccounted sales.
Unaccounted sale. Sales were made, but there was no account for them. 14.2 kg filled cylinders found, 407 numbers, and in empty 14.2 kg cylinders found 227 numbers in the physical stock. As per the book stock, minus 31 numbers, 14 filled cylinders, and 1,100 numbers, 14.2 kg empty cylinders were observed. Hence, unaccounted sale observed in field 14.2 kg cylinders is 31 plus 407, 438 numbers, and 872 numbers for empty 14.2 kg cylinders. Now, first one was shortage. The first discrepancy number 2 was shortage of more than 50 cylinders, which is a violation of MDG guideline. And the third one, unaccounted sale, because in the physical there is a variation in the physical stock and the stock register, book stock. So that for that it was observed there is an unaccounted sale actually sale made, but those were not accounted. Now this was the third. Now the fourth discrepancy, non-compliance of pre-delivery checks for refills done before delivery of refills by distributors of distributor, which is a violation of MDG 2.2.9 clause. Safety check kit was not available with the delivery boy during inspection. So this was also en route. The fifth one is also en route. The safety check kit was not available with delivery boy during inspection. This was en route. Now the next discrepancies. Point number 6. It is at the showroom. Showroom staff, mechanic, delivery staff not found in uniform while on duty. This is also a violation of the MDG guidelines. There are certain other observations like mastic floor of godown was broken, and there are other small discrepancies like physical stock and inventory stocks were nil. Then cylinders were short. Empty cylinders were short by 11 cylinders, because he has to also keep the record of like how many empty cylinders were there, how many defective cylinders were there, because as I told you on losses on the last occasion, that at the godown there will be three separate places for storing the cylinders. One is the filled cylinders, which are matching all the parameters. Second one is the defective cylinders, which were
placed aside.
Right. And the third place will be for empty cylinders. So separate places should be there in the godown for stocking 3 different kind of categories of cylinders. Now, so far as the empty cylinders are concerned or the defective cylinders is concerned, there has to be proper record to maintain the numbers. Like how many defective cylinders were there, there has to be proper record. How many empty cylinders were there, there has to be proper record maintained, so that the IOCL can take the defective cylinders and found out how many cylinders which were actually delivered. Out of those, how many were found to be defective. At the same time, when the filled cylinders are unloaded at the godown, at the same time MC cylinders will also be uploaded in the same delivery van. So accordingly, the number of empty cylinders, the proper number of empty cylinders will also be there in the record of Internal Corporation, and it can only be there when the same record is properly maintained with the distributor at the godown. So discrepancies with regard to these stocks were also found, and that is one this main other observation. Now kindly see how all these 6 and all these discrepancies were dealt when the first opportunity was given along with all the inspection report to the petitioner. '86, page 86, volume number 2.
This is the reply.
This is the reply.
Yes.
Now point he has given reply. Point number 1, it has been quoted, the discrepancy has been quoted.
Yes.
Then he has mentioned what is his answer. Now point number 1 is the main contention. The subject matter of dispute is point number 1, underweight cylinders. Now kindly see what is his explanation to that, answer to it. A few were borderline cases.
Yes.
So it's a clear admission. But according to it's a borderline. Explanation is borderline, but discrepancy is admitted. Underweight is admitted, but according to her, it's borderline. A few were borderline cases, but more importantly, the van men were only preparing to load the vans. When the SQC team arrived, they had not yet left godown with the cylinders when the inspection happened. See also point number 5. So far, here is the reply, the case made out in the reply is that the inspection which had happened, that was not actually en route. It was within the godown premises, and the delivery boy was supposed to unload were loading. The loading was still in process. Our case was the loading was still in process, and they were
yet not en route.
Yes.
It was within the periphery of the godown,
Right.
and they were loading.
They were just loading.
Preparing to load or loading the
loading. So far as discrepancy is concerned, no defense. No case has been made out that the proper weigh machine were not used. The inspection in the inspection report, only 1 digit after the decimal was shown, which is in violation of the rules.
What was the argued before discussed?
Right. This point was not taken at all, because I told you last on the last occasion that these weighing machines were provided by the distributor herself. The hand weighing machines belongs to distributor. The platform weighing machines were also belongs to distributor. So the hand weighing machine on which the cylinders were weighed, those were provided by the distributor. If there is any defect in the hand weighing machine, it is the responsibility is with the distributor, not with the renal corporation. If the hand weighing machines only shown 1 digit after the decimal, so it is the responsibility of the distributor to provide a proper weighing machine which will show 3 digit after the decimal. The inspection, I also told you, shown you losses, the inspection report, it is also there here also. If you losses sees the so cause, because with this so cause notice, the inspection reports were also enclosed, and the inspection reports were also annexed here also. If I kindly sees the inspection reports once more in the first volume, my lord. I shown to your lordship on those 2 pages, page 80. At page 80. Now these were
SQC en route go down.
Right. these weight were the women were specifically provided here. Writ petitioner pointed out that after there is one decimal shown after the there is one digit shown after the decimal, which is in violation of the guideline. Now my submission is this has been done on a weighing machine provided by the distributor. If the weighing machine showed only one digit, then the responsibility is with the distributor to provide a weighing machine which will show 3 digit after the decimal. Now, this inspection, on-spot inspection report were duly countersigned by the delivery man, by the inspection team, as well as by the writ petitioner. Kindly see the writ petitioner's signature at the bottom, Maloji Shah. The delivery boy signature is also there, as well as the inspection team's signature is also there. No protest at the first inspection during the inspection was made by the distributor. And not only that, even in his reply to the show cause also, she has not pointed out this issue. So in my humble submission, when she has not pointed out this issue in his show cause reply, she cannot be permitted to improve her case or permitted to deviate from her admission which he has made in the reply to the show cause notice. Yes. Now, my lord, kindly sees the show cause reply in respect of the other discrepancies. In respect of point number 1, yes. Now, my lord, kindly sees the second volume at page 86. The reply. I have shown the petitioner's reply to the discrepancy number 1, where she also refers. See also point number 5. She also refers her explanation to point number 5. Now, kindly see what are explanation with regard to point number 5. The next page. Non-compliance of delivery checks for refills done before delivery of refills by distributor staff, distributor, violation of MDG guideline clause number 2.2.9. This is denied as vanmen were merely preparing to load and getting ready when checking was done. They always carry necessary safety kits needed for leakage and weight checking as per norms and demonstrate the same at customer premises. Delivery boys demonstrated or pausing here for a moment, my lord. In the second line, as I submitted, my lord, that this women checking, the women checking machine, the women machines were carried by the delivery boy. Kit. Not only kit, weighing machine also. Kindly see the next.
What is the point number 5 regarding discrepancy? Safety check kit was not available with the delivery boy during inspection. This is the observation of so-called discrepancies appear.
Right. See,
what is their answer?
In reply to that, she says, this is denied as the vanmen were merely preparing to load and getting ready when checking was done. They always carry necessary safety kits needed for leakage and weight checking. So for women also, as I submitted, for women also, it's the delivery boy of the distributor who carries the women machine.
Yes.
It's not the corporation who provides the women machine. It is distributor's machine as per norms and demonstrate the same at customer premises. delivery boys demonstrated to QRC team how to use safety kit. Regarding the delivery boy Radhesham's report, we pointed out that the safety kit availability should be yes, which the QRC team promised to correct. So where the checks were given, if you losses kindly again come to page 80 of the first volume where the inspections report was annexed, my lord. After the chart at page 80,
yes.
After the chart at the bottom, one delivery boy in uniform with ID card, right hand side, yes or no. So it says yes. Then electronic weighing scale available with at least count plus minus 10 grams. Whether it was available or not, yes. Availability of safety check kit, O-ring, valve leak detector with delivery boy for PDC. Yes. So these were there. Now kindly see the next page. This was in respect of one van. 80 is in respect of one van. There were inspection in respect of two vans. This is in respect of one van. The delivery boy was NK Singh, and the next page 81, the delivery boy was Radhesham. And this was in respect of the another delivery van. Now if you losses kindly sees the third point at the bottom where it says availability of safety kit, O-ring, valve leakage detector, it says no. So this is why that point number 5 was given in the show cause safety kits were not there.
Yes.
So in reply to that issue, the petitioner's case was that it was available, but it was a mistake by the inspection team to record it as no instead of yes. And it was pointed out to the inspection team, and inspection team that said that yes, we will correct that. So that is her case, that he's denying that that safety kit was there. So even if we read her explanation in regard to point number discrepancy number 5 with discrepancy number 1, then the fact remains her explanation so far as 1 is concerned is that no dispute with regard to the women. Her case was that those were borderline cases. No dispute with regard to the weighing machine. No dispute with regard to the women recorded at the inspection book. Her only case, those were borderline cases.
Answer is that they have not yet left the godown and it was only borderline.
Borderline cases. The discrepancy were borderline cases.
And they are preparing to load the vans.
Right.
This is the only issue they have demonstrated before the authority during reply to the so cause
notice. Now, my case is at this stage, the third appellate stage, if I may say, this point cannot be agitated. This issue cannot be made. Issue cannot be agitated. Even if I can demonstrate that I will make my submissions on the merit of that case made out, but my preliminary objection in particular to that issue is this issue cannot be raised before this honorable court in the writ petition because these were not taken at the first stage.
So challenge before this writ court is a decision.
Decision.
Is the decision of the competent authority.
Right.
So decision of the competent authority in respect of the answer. In respect of the answer given by the petitioner.
Right.
So your argument is the answer of the petitioner not reflected what they are arguing before this writ court first time.
My lord. My lord.
Whether this can be entertained at this stage, this is the question.
My lord. Now, if a logist kindly sees the first speaking order. This was one case, and my another case was that had it been a case the writ petitioner had any objection with regard to the weighment taken, with regard to the weighing machines, or with regard to the weighment recorded in the inspection report, if the writ petitioner had any objection with regard to the same, the first opportunity she got for recording her objection was the inspection report itself, because she has done so in respect of the inspection carried out at the showroom. I have shown to your lordship the inspection report of the showroom. Kindly see once again, my lord.
During inspection in the showroom, they have raised some questions.
Yes, they have raised certain objections, she has recorded her observations. Page 78.
Yes.
78, right hand side bottom, the broader portion where handwritten observations were there. This observation is by the dealer, the distributor, based on the inspection report. This is the inspection report, and on this whatever has been recorded by the inspection team in this report, she had made her observation in writing in that inspection report itself. Certain type of clarifications where why this mismatch of physical stock and the book stock are there. In respect of those charges, she has made her observation. So she got an opportunity. It was not at all her case. I may say in like this manner, this is a case which is tried to be made out at the third appellate stage. This was not her case at all in her so-called reply, not even during the inspection also. Otherwise, she could have provided a proper weighing machine which will show 3 digit after the decimal. Because weighing machines, the inspection team did not provide the weighing machine. Inspection team asked the delivery boy to weigh the cylinders. The cylinders which were loaded on the van, delivery boy was asked to provide the weighing machine to weigh these cylinders which were loaded on the delivery boy.
Okay.
So if my learned senior friend has referred metrology rules, saying that as per metrology rules, it has the weighing machine should show 3 digit after the decimal. Now I have shown to your losses the so-called notice where in respect of the first discrepancy we had referred the rules also, the metrology rules also.
In each question, in each discrepancy, you have mentioned
the relevant laws, regulations and rules. So far as first discrepancy is concerned, we have mentioned not only MDG, we have also mentioned the metrology rules, which my learned senior friend is now relying on. The entire case made out in the writ petition is only on the basis of the metrology rules, which mandates a weighing machine to be used, which will show 3 digit after the decimal, because that may create huge difference in the women.
Yes.
Now, when a so-cause notice was issued referring to that particular metrology rules, petitioner got an opportunity to deal with that rules itself in her reply. She chose not to do so. In her reply, she has not taken a point that you have referred the discrepancy as per metrology rules, but you see the metrology rules mandates weighing machine to women to be made on a weighing machine
3 digit after decimal,
which you have not which you have violated. This is not a case made out in the so cause to the reply. Because not only the discrepancy, also the metrology rules were also referred in the so called notice.
Yes.
Now, so far as the contention of the writ petitioner in the so cause as well as now, that the inspection actually happened, did not happen en route, it actually happened in the godown. I have shown the inspection report which says it happened en route. In their reply, they have taken a point, it happened actually in the godown. Now, so far as this particular question is concerned, in my humble submission, this is a disputed question of fact and cannot be adjudicated in the writ petition. The question as to whether the inspection actually happened en route or at the godown, that cannot be decided in the writ petition.
Factual matter, sir.
It's a completed factual matter, and it's a highly disputed question of fact, because we are saying it happened en route, writ petitioner is saying it happened godown. So this fact is disputed, and this disputed question of fact cannot be adjudicated in a writ petition. Now, my lord, kindly sees the speaking order, the first speaking order which was passed after considering after conclusion of the so cause proceeding.
Yes.
Page 106.
Yes.
Now, it again quote the discrepancy at the first page. It quote the discrepancy which was mentioned in the so cause. Then, my lord,
distributor reply
exactly what she has mentioned. Now, the remarks of the corporation, so far as this question is concerned. As per
yes.
As per MDG guidelines 2022, under clause number 1, procedure for handling of LPG cylinders by distributors, 1.4, quality quantity control measures.
As per MDG guideline.
Right. All the cylinders taken out for delivery should be checked for correctness of net weight on the platform type. Now, I also may remember, I also submitted that showing the MDG guideline, which my learned senior friend has also referred, that the clause 1.4. 1.4 is not the responsibility of compliance on 1.4 is not the responsibility of the corporation. Weighment on a platform weighing machine, that job has to be done by the distributor. That was not the responsibility of the corporation as the argument was made. They should have weighed the cylinders at the weighing machine, a platform based weighing machine, because that is what mentioned at clause number 1.4. In my humble submission, that responsibility is with the distributor, not the corporation. It says, before all the cylinders taken out for delivery should be checked for correctness on net weight on the platform type digital weighing scale of at least count plus minus 10 grams prescribed in the legal metrology packed commodities rules 2011. That this is where it my learned senior face has referred. There is a violation of, there is a non-compliance of this provision. So if it is a case made out by the petitioner that there is a non-compliance of this provision, then in my humble submission, this non-compliance is at the instance of the petitioner, not by the corporation. If clause 1.4 has not been complied with, then petitioner has not complied with. It is not for compliance of the corporation.
all weighing machines, weighing scale, everything is in the possession and under the custody of the petitioners. They have to comply with clause 1.4. If their scale showing not plus minus 10 gram count, then it is their fault. It is your submission.
No, not only that. Petitioner tried to make out a case that point 1.4 says that the weighment has to be done on a platform based weighing machine.
Yes.
However, the weighment was done on a hand weighing machine. So there is a violation of 1.4. That was the case made out.
Yes.
In my humble submission, 1.4 is not related to inspection. 1.4 is in respect of the distributor's accountability. This process has to be done by the distributor before loading the cylinders for delivery on the van. This process has to be carried out, because if you see the last line also, as such, distribute that clause, cylinders that have net weight beyond permissible limit prescribed in the legal metrology pack commodities rules 2011 as amended from time to time should be segregated and returned to concerned bottling plant. So this exercise has to be done by the distributor before, because this segregation has to be done earlier, because she had after segregating the cylinders which are within the the weighment of which are within the permissible limit, those have to be kept at a proper place before loading the same on the van, because the segregation has to be done by the distributor. Underweight has to be sent to the bottling plant.
1.4
Yes.
is the provision regarding the at the time when the cylinders are received or when the cylinders are going to en route.
This has to be done before a particular cylinder is loaded on a van for delivery.
Through en route.
Right.
Going to en route.
Not only en route, even the delivery, if the van is
at the time of receiving also, you are
yes, that is a different provision that I will again show. Even at the time of receiving also, there will be a random
segregation.
There will be a random
Random check.
Right, there will be a random. That will not be like the entire lot will not be weighed. There will be a random.
So at the time of en route, each and every cylinder has to be weighted
before it is loaded on the delivery van. Even if the delivery van is located, is kept inside the godown, but it says kindly see point 1.4D quoted here also. Cylinder with correct net weight only should be taken out for delivery to the customers. So this segregation has to be done at the instance of the distributor. Indian Oil Corporation will come for an inspection, then the segregation will be done. It's not a case. Like for each and every day, there will be several deliveries. So Indian Oil Corporation's inspection team will not be located there. It will not be stationed there to check each and every delivery. So it is the responsibility of the distributor to maintain this exercise for each and every delivery. It was no one's case that the weighment of the cylinders which found to be underweight were located at the godown. It's an admitted position that those were already loaded on the delivery van. The dispute is where the delivery van was situated, in whether within the godown premises or en route. There is a dispute with regarding to that issue, but admitted position is the cylinders were on the delivery van.
Yes.
So whenever a cylinder is on a delivery van, that means it has been already, that particular cylinder has already been chosen to be delivered to a customer. Now,
Okay, I
what is the finding of the authority so far as this particular given discrepancy is concerned? Hence, before loading cylinders in delivery vehicle, all cylinders should be checked for correct weight. As per inspection by QRC, more than 25% of the filled cylinders loaded in a delivery vehicle for delivery to customers found underweight beyond permissible limit prescribed in the legal metrology Packed Commodities Rule 2011. As such, distributor's reply is not found to be satisfactory. Thus, as recommended by field officer, major irregularity under clause number 2.1.2 of MDG 2022 is established. So this entire finding, is based on the reply. Today, petitioner cannot be permitted to improve her reply.
Yes. Yes. So this point, petitioner has argued a lot.
This is the only point which has been argued. This is the only point. Other in respect
Other
of the other discrepancies, nothing has been argued. This is the only discrepancy in respect of which this writ petition has been mainly filed. Now, my lord, kindly sees now the appeal.
Order by the appellate forum.
No. The appeal filed by the writ petitioner before the appellate forum, which is at page
Memo
115.
115. Appeal against the speaking order.
Kindly see, may I place from the last paragraph, because the other first two paragraphs are the fact, like the what has happened. Now the submissions from the last paragraph at page 115.
Yes.
My association with IOCL has been a source of pride for me over last 41 years. I have devoted numerous precious years of my life to your esteemed organization, contributing wholeheartedly as a lady distributor, one of the first to build a loyal customer base for IOCL all these years. However, recent developments have shattered my sense of pride and trust. The ordeal began on the day of inspection conducted by the QRC. In response to the subsequent show cause notice, I diligently submitted a comprehensive and suitable reply addressing each concern raised. Unfortunately, the process took an unexpected turn when a speaking order was hastily issued, seemingly without a thorough analysis of the facts presented. So here also, her entire case is based on the reply submitted. She is again tracing her reply in her appeal. According to her case made out in the appeal is her reply was not properly considered by the authority. That was her case before the appellate authority also. This has left me disheartened and concerned about the fairness of the decision-making process. As someone who has invested a significant time and effort in building a successful partnership with IOCL since 1982, I am left grappling with doubts about the transparency and integrity of the recent proceedings, particularly at the fag end of the first line in between is not legible. Now maybe it's the next paragraph. I hope that the organization will evaluate the situation sincerely, considering the years of dedication and service I have devoted to IOCL. I request your dispassionate and impartial review of the circumstances surrounding the recent developments. This is not only for my sake, but also to preserve the trust and mutual respect that has been the foundation of our association. I believe in the values of that IOCL upholds, and I trust that my concerns will be heard and addressed appropriately, fostering a resolution that preserves the integrity of our long-standing partnership. Now, she refers to the further inspection. Then she refers to a further inspection which happened at a later stage during the after the first inspection. If you see, the first inspection happened on 14th of July 2023. The inspection report, if you see, is at page 80. The date
14th
is
of July.
14th of July.
Now, why second inspection?
There is no second inspection at all. She says there was another inspection on 18. As per our records, 2 inspections were conducted by QRC team on 14 July 2023 and 18 July 2023 simultaneously. Even if assuming there is an inspection on 18 July, the subject matter of dispute relates to a so-called proceedings, which relates to an inspection which happened only on 14th of July. So even if assuming there has been an inspection of 18th of July, but the proceeding does not relate to that inspection at all. So reference of the second inspection, there is no question of considering the issue with regard to the inspection which was carried at a later stage.
Yes.
Now, she want to make out a case saying that there were during the second inspections, everything were found to be in place. So some misunderstanding happened at the first place. So those should be properly considered. That is all our case. Nothing in relation to weighing machine, nothing in relation to the violation of the metrology rules, nothing, nowhere. Even at the appellate stage, she strictly relies on her reply. According to her, her reply was not properly considered.
Yes. Nothing regarding the plea.
No, kindly see the next page, page 170.
Yes.
Third paragraph from top. It is imperative to note that the weighing of all cylinders occurred at the godown by the QRC. So now,
no,
she is referring to
you read the second paragraph.
Yes. Third paragraph from top. It is imperative to note at page 170.
Okay, got it.
Occurred at the godown. Now she is referring to the inspection which happened at the godown. According to her, this inspection happened at the godown before loading them into van.
Yes.
Here she says that those were because in the first the cylinders which were found to be underweight, were actually at the godown and were not on the van. Because the inspection happened before the cylinders could be loaded on the van. Now here she refers that since the cylinders are yet to be loaded on van for delivery, the cylinders were still at the godown, then the weighing machine should have been used as the platform based weighing machine. Point 1.4 has been referred.
Yes.
Now, what is her explanation? Saying that it is a fact that none of the cylinders were measured or on platform weighing on weighing platform as mentioned in your MDG process.
Yes.
She is referring to clause number 1.4. One number 1.4 says it has to be weighed in the platform-based weighing machine before it is loaded on the van for delivery. And I shown to your losses that it specifically says that it is the responsibility of the distributor. It is not the duty of the corporation. It is not the duty of the inspection team. It is the responsibility of the distributor. Here she says that since it was at the godown, not loaded on the delivery van for delivery, so it should have been weighed on the platform weighing machine. Pausing here for a moment, if had it been a case that it should have been weighed on the platform weighing machine, it was open to the distributor. She was there. She signed the inspection report. She was there. She could have weighed on the weighing machine, platform weighing machine, showing that it was perfectly all right. It was not underweight.
No. You read the second paragraph.
Yes.
You read the second paragraph. The entirety of the cylinder cited in the QRC report, he has dealt with this issue. In second paragraph, page 117.
Yes, the entirety of the cylinders cited in the QRC report, encompassing a total of 26 cylinders as part of the random weight verification of field cylinders at the godown or SQC en route, were subjected to weighing procedures at the godown. This information is substantiated by the QRC report, which explicitly indicates that all these 26 cylinders underweight weighing at the godown. Doesn't make any sense. The inspection report does not say so.
20 cylinders were 10 plus 10. 20 cylinders were
found to
weighted, counted.
Yes.
Now they have stated 26 cylinders.
26. She relies on the inspection report. What you will also sees the inspection report at page 80 and 81. And her case is that the procedure which is laid down in point number 1.4, clause number 1.4 of the MDG guideline should have been followed. But that was the responsibility of the distributor, not the corporation. First. Second is, my specific case is that it happened en route, not at the godown. Because the cylinders were already loaded on the delivery van. Now, here also she again admits, Malika, this second paragraph, kindly see the second paragraph.
Yes.
Third line, may I read again? This information is substantiated by the QRC report, which is not there, which explicitly indicates that all these 26 cylinders underwent weighing at the godown. It also does not say so, the report. Out of the 26 cylinders scrutinized by the inspecting officials in godown, we understand that 5 were found to be minutely underweight, video reference number 6. We pointed out that such slight variations in weight could potentially be attributed to factors like the shaking of the hand while uplifting the cylinders for women, particularly considering. So variation is admitted. Now she says that the variation might have happened because of the hand weighing machine had been used. but she was there. Platform-based weighing machine was also there. She could have got the women done on the platform-based weighing machine. The weighing machine has been provided by her, hand weighing machine. Here also, deviations is not record. Metrology rules provides the recording should be 3 digit after the decimal. Here also she does not say. Her only case is that it happened at the go down, not en route. So it should have weighment should have been done on the platform based weighing machine and not hand weighing machine. So because your clause of 1.4 says it has to be done on platform based weighing machine. That is our clarification.
So you go to the next point. He has raised that point. Paragraph 4.
It is crucial.
But in first QRC report.
Yes. In fact, yes, I read this.
Yes.
In fact, none of the cylinders were measured on weighing platform as mentioned in your MDG process. So her case is key. It actually the inspection happened at the go down, and clause 1.4 of your guideline says that cylinder has to be weighed on the platform based weighing machine, and so you have not followed that process. You have not used the platform based weighing machine. And I have shown to your losses the 1.4 says it is the duty of the distributor.
Yes.
Not the inspection team. It was her choice. And suppose assuming that the inspection happened at the go down, even if we assume without admitting that inspection happened at the go down, then also it was open to the distributor to get the weighment done on the platform based weighing machine because that was her responsibility as per clause 1.4. She chose not to do that and provided a hand weighing machine to the inspection team for the weighing. She chose that process at her risk. Now she can't say that the deviation happened only because because of handshaking and all the hand weighing machine was used. And even here also she has not taken the point which was the only point which was argued before your lordship, that referring to legal metrology rules, that weighing machine which records 3 digit after the decimal should be accepted. That she has not said. Even here also, in the appeal also. Now kindly see the kindly continue on the next page. I will I think the next day I will complete.
Right. Tomorrow?
Process may permit me tomorrow at 10:30. Then I
No. 10:30 I have other determinations.
My lord, I have also some difficulties, my lord, tomorrow.
Then forget it.
Next, following week.
Next week. Next Thursday.
At 2 p.m.
At 2 p.m.
At 2 p.m.
Please take down argument on behalf of the IOCL hard in part. IOCL, the respondent hard in part. Let the matter appear in the list on 27th at 2 p.m. for further argument. গরম করছে তো ফ্যান বাইরে চালাতে হবে।
May I please, Your Lordship. My Lord, I was arguing this matter. This is, my Lord, Mr. Surana's appeal under Section 37 of the Arbitration and Conciliation Act,
Yes.
where he's, my Lord, challenged an order rejecting or dismissing his application filed before the arbitrator under Section 17. Can you give me one more? Now, before I continue with my arguments, my Lord, I'll just take 1 minute to, my Lord, briefly recapitulate what I have submitted on the last 1 or 2
You
occasions.
submitted firstly on the basis of possession.
Yes,
Started
that
the-
is my main argument.
Yes.
That in fact, initially, my Lord, I had tried to demonstrate to this court, my Lord, what is the scope of Section 37,
Yes.
how it is a very limited scope, unlike other appeals. The scope of interference as contemplated by the Arbitration Act is very minimal. And the court cannot, in terms of Section 37, substitutes its view with the arbitrator's view. If the arbitrator has taken a view and it's a plausible view, that view must be accepted at this particular stage because it is at the interlocutory stage. It is at the interim stage.
Yes.
The only perhaps ground or 2 grounds where the court can interfere, if it is shown or proved beyond doubt that there is some perversity or patent illegality in the order passed by the arbitrator under Section 17. My Lord, the claimant's claim in the Section 17 application was with regard to seeking security. He asked for security on the basis that I am allegedly in possession of the premises, and therefore he is entitled to occupation charges, which I am not paying him, and therefore I should secure his claim for these occupation charges monetarily, money security. The Lordship will kindly keep 2 things in mind. Firstly, my Lord, of course, forgetting the merits of the argument that I'm not in possession, even assuming whether he is right, my Lord, he is an unsecured creditor at the highest. If he is to be believed that I am in possession and I'm not paying him, then he is my creditor. I am a debtor. And he is, my Lord, with the greatest amount of respect, an unsecured creditor. He has no security. So what he is trying to do through this application under Section 17 is to secure himself. An unsecured creditor is attempting to become a secured creditor, which is impermissible in law. And I will rely on judgments. Secondly, his claim at all, if he is entitled to it for mean profits, occupation charges, that is an unliquidated claim. It is not a liquidated claim. It has to be decided
Yes.
as to whether at all he is entitled to any money, and if he is, to what extent or how much. So therefore, I say his claim, if at all it is a rightful claim, that is an unliquidated claim. My respectful submission will be at all points of time that he has failed to make out any case for security to be given by the respondents. Well, so far as the aspect of possession is concerned, which Your Lordship pointed out, yes, that is my main thrust of the argument, because it is a sine qua non that if he is entitled to any claim at this juncture or any security it is at this juncture, he must first establish that I am in possession or in occupation of the premises. I have shown, my Lord, on the last date or the date before that, the interim award, where, my Lord, I had agreed to give him possession, where a consent award was passed, saying that yes, an award can be passed in his favor, entitling him to take possession. And I had given my consent for the same, because I had already handed over possession of the premises prior to the interim award being passed.
Yes.
And I had shown, my Lord, in support of my argument and contention, my affidavit in opposition, which I had filed against his application for interim award in the first arbitration reference. Secondly, I have shown Your Lordship the final award, paragraphs 33 to 41, which, my Lord, deal with the aspect of possession. how the learned arbitrator in the first reference has categorically come to the conclusion that yes, possession was handed over. Yes, it was not vacant possession, but vacant possession, it was not possible to hand over vacant possession because of the claimant himself. And in fact, the claimant entered into direct relationships with the occupiers who were my sub-licensees.
Yes.
And Lordship will recall, my lord, that the final award was passed in the first reference after a full-fledged trial, evidence, witness action, etc., etc. So therefore, my lord, the findings, the factual findings in particular, in the first reference, my lord, they will operate in my humble submission as res judicata. This was my submission before the arbitrator as well during the time of hearing of the Section 17 application, and I make those submissions before your lordship as well. Res judicata, or in the alternative, a legal phraseology, my lord, issue estoppel.
Yes.
This issue has already been decided. You cannot now reopen or re-agitate this issue once again in this appeal under Section 37. I had also shown your lordship, my lord, that the bank, and what Mr. Mukherjee also submitted today in the other matter, that the bank is also receiving rents, and the receiver was also appointed by the Debt Recovery Tribunal in the action filed by the bank against Mr. Surana for claiming their outstanding. So this is, my lord, where I had stopped, my lord. My respectful submission will be that he has not been able to give even an iota of proof or evidence to show prima facie that I am in possession of the concerned premises. And this is where I will continue from, my lord. Lordship, on the last occasion, my lord, have been pleased to call for the records of the stay petition. I hope that has come, my lord.
Yes.
My lord, I'll take your lordship straight away, my lord. To, my lord, some documents, the only few documents which he has relied on to show or to try and show that I'm in possession of these premises. Now, before I show your lordship, my lord, two sets of documents were shown. One is, my lord, certain bills, and two is, my lord, certain TDS certificates. Kindly, my lord, take page 134 of the stay application. That is possibly, my lord, in volume 1. This is the document, my lord, Mr. Surana, or rather Mr. Sen, has relied on to claim that I'm in possession. Lordship has the document.
Page?
Page 134, my lord.
Yes.
Well, you will kindly see, my lord, these are some two bills, one on the left-hand side and one on the right-hand side, which have been annexed, my lord. My lord, kindly take either of the bills. Kindly take the bill on the left-hand side. Kindly take the top, my lord. Tax invoice, bill of supply. Kindly see the second line. Big Bazaar, and within brackets, Future Retail Limited, Puja Mall. And what has been purchased by one fake purchaser, or rather a setup purchaser, some Jira, etc., for 138 rupees. So Mr. Surana is relying on this bill, as also some other bills, to show that I am allegedly in occupation and possession of the premises. My respectful submission, my lord, is that these bills do not show that I am in possession. My lord, will see who I am. I am, my lord, respondent number 2, which is Future Market Networks Limited. And the respondent number 1, my lord, is Future Enterprises Limited. This bill has been issued by one Future Retail Limited, who is not a party to the arbitration, who is not a party before your lordship today, and who in any event is not me, or for that matter, even the respondent number 1. So if at all these bills show anything, these bills at the highest can show that Future Retail Limited is in occupation at that point of time, and not Future Market Networks Limited, my client, or the respondent number 1 for that matter, Future Enterprises Limited. And this Future Retail Limited, Mr. Surana, or rather Mr. Sen has also submitted, has gone into CIRP before the NCLT in Bombay. And in fact, I'll show your lordship a document later on. The interim resolution professional, the resolution professional appointed by the NCLT in Bombay, has also communicated with Mr. Surana so far as their occupation of these premises is concerned. I'll show that document. So, my lord, these bills which are at page 134 and 135, I will not trouble your lordship by showing all the bills one by one. They do not in any manner demonstrate or prove that the respondent number 1 or the respondent number 2 is occupying or is in possession of the premises. In fact, it shows that somebody else is in possession of the premises. So I'm grateful to Mr. Surana for having brought this document on record, because this only establishes that somebody else is occupying the premises and not me. Now, the other set of documents which is relied on, my lord, are at pages 136 to 139 of the stay application. These are, my lord, forms 26 AS from the Income Tax Department, my lord, which basically show, my lord, what TDS has been deposited in favor of Mr. Surana for the relevant financial years. Kindly, my lord, take a sample form at, my lord, page 136.
Yes.
Your lordship will see, my lord, towards the top on the right-hand side, in black and white, there's the word, my lord, financial year written, and 2017 to 18 is mentioned.
Yes.
So this form is for 2017 to 18, and the name of the assessee is mentioned on the left-hand side, my lord, where you, my lordship will see Mr. Surana's name, Lakshmipat Surana. So this is, my lord, form 26 AS for Mr. Surana's income tax file for the financial year 2017-18. Kindly, my lord, come thereafter a little below. Kindly take, my lord, towards the middle of the page, slightly below, name of deductor, and once again your lordship will find the name of the company, Future Retail Limited. The first one, name of deductor, is UCO Bank Hastings. Next deductor is UCO Bank of India. And the third deductor, my lord, is Future Retail Limited.
Yes.
So, my lord, once again, my lord, this is the same Future Retail Limited whose bills have been annexed at pages 134 and 135. So, all that this document, this Form 26 AS shows, is that Future Retail Limited is deducting tax and depositing it with the Income Tax Department for the benefit of Mr. Surana. I am not Future Retail Limited, neither is the respondent number 1 Future Retail Limited. Mr. Surana's attempt was to show that, look, you are depositing income tax and not paying me my dues, but that is not the case. The case is, my lord, somebody else is depositing the tax deducted at source and perhaps not paying him. I'm not going into that. Similarly, my lord, pages 137 is same document for the financial year 2018-19. Again, it is Future Retail Limited who has deducted tax and deposited with the Income Tax Department. Page 138 is for the financial year 2019 to 20. This also shows, my lord, Future Retail Limited. And page 139, 2020 to 21, again shows Future Retail Limited as to how, my lord, they are deducting tax. And in fact, my lord, it says that they have paid or credited Mr. Surana's account. Now, Mr. Surana may dispute that, but then that will be a triable issue. Lordship will take any of these columns, my lord. If your lordship has at page 139, I'll just show. Name of deductor, my lord, is mentioned as Future Retail Limited.
Yes.
And there are about 8 deductions made by Future Retail Limited in that financial year. Kindly come, my lord, the next to next column, my lord. The date of bookings are mentioned, and kindly see, my lord, amount paid or credited. So, my lord, as per this statement, it appears that Future Retail Limited has paid or credited this amount, these various amounts, 15,40,390, 15,40,390, 2,09,20, etc., etc. And for each of these payments which they have made to Mr. Surana for his benefit, they have deducted, my lord, possibly 10% tax and deposited the same with the Income Tax Department. So, my lord, 2 things arise, my lord, from this document. Firstly, my lord, it shows that I am not in possession, that I am not paying any money to the Income Tax Department or to Mr. Surana because I have no liability whatsoever. But it also shows that somebody else, that is Future Retail Limited, is not only depositing TDS, but perhaps is also paying money to Mr. Surana. And these are the only documents, my lord, which he has relied on to show that I am allegedly in possession of these premises. My respectful submission, these documents do not even in the slightest bit indicate that. Now, my lord, will thereafter come, my lord, to the section 17 application, which is, my lord, at page 145 of the stay petition in volume 2. Kindly see what is the case he has made out in his section 17 application, in which the impugned order was passed. Well, it starts, my lord, at page 145. Kindly take the cause title for a moment. There is some relevance as to why I'm relying on the cause title or bringing it to your lordship's notice. The arbitrator's name is mentioned, my lord. Then in the matter of Arbitration and Conciliation Act 1996, then, my lord, the application is described in the matter of an application under section 17 of the said act read with order 38 rule 5 of the Code of Civil Procedure. So this application is an application under section 17 of the act read with order 38 rule 5, and naturally he has relied on order 38 rule 5, which is in the nature of attachment before judgment, where any security is required. I will show, my lord, rely on judgments. I will rely on the Code of Civil Procedure that in any event, even assuming I am in possession, he has failed to make out a case under order 38 rule 5 of the Code of Civil Procedure. Now, your lordship will just kindly take a few of the relevant paragraphs so far as his claim is mentioned. It's a short application. I'll just rely on a few paragraphs. Kindly, my lord, come to page 150, 150, and take paragraph 4E onwards.
Yes.
Well, paragraph 4E, well, I'm placing these paragraphs, well, I'll place 4E to 4K. The claimant filed its statement of claim in the earlier reference, inter alia praying for an award for a sum of rupees 255 crore 80 lakh 42,215, along with interest, as well as an award for possession of the demised premises after eviction of the respondents therefrom. My lord, I pause here for a moment, my lord. Mr. Sen's submission was, my lord, one of his submissions was, he had two primary submissions. He had indicated to your lordship that in the earlier reference, before the first arbitrator, Mr. Shama Prasad Sharkar, who's no more, the issue of possession was not there. That, my lord, is wholly incorrect. And that is clearly stated by Mr. Surana that it included his prayer was for an award for possession. So issue for possession or the aspect of possession was definitely an issue in the first round of reference, which is why, my lord, res judicata will come in. Because Mr. Sen was perhaps trying to contend that since the possession was not an issue before the first arbitrator, therefore it will not operate as res judicata. But my counter to that is, issue of possession was definitely an issue, therefore the aspect of res judicata will come in. And I'll show the statement of claim also. But in any event, it's pleaded out here that he had filed the first arbitration for possession after eviction of the respondents therefrom. Kindly take, my lord, paragraph F thereafter. On or about 9th January 2013, the claimant filed an application before the learned arbitrator, inter alia seeking interim award for a sum of rupees 23 crore 95 lakh 50,719, as well as for delivery of khas, vacant and peaceful possession of the said demised premises against the respondents. The learned sole arbitrator, by order dated 8th April 2013, this is the interim award, was pleased to pass an interim award in favor of the claimant for khas, peaceful and vacant possession of the demised premises. The interim award has not been challenged by the respondents till date, and the same has attained finality. However, despite the said interim award passed upon consent of the respondents have not yet vacated the premises and have been continuing in wrongful and illegal occupation or possession of the said premises. Copy of the interim award is annexed. Paragraph G, my lord. The learned sole arbitrator was pleased to pass the final award on 19th May 2016, inter alia holding that the claimant is entitled for a sum of rupees 18 crore, 16 lakh, etc. from the respondents, whereas the respondents would get rupees 5.26 crore on account of their counterclaim set-offs from the claimant. The same is assailed under section 34 proceedings before the Honorable High Court by both the claimants as well as the respondents. Here, my lord, he is conspicuously silent about the fact that the award records that possession was handed over. Be that as it may, my lord. Kindly, my lord, come to the next page, paragraph 4H. Despite such interim award, which was passed on the concession of the respondents in the earlier reference, till date, thus vacant and peaceful possession of the demise premises has not been handed over by the respondents. So he completely ignores the fact that the final award records that possession has been handed over. Being aggrieved by such aberrant behavior, the claimant has invoked arbitration clause by issuing notice dated September 24, 2016 for resolution of disputes emanating on account of wrongful occupation of the respondent after passing of interim award in April 2013 without payment of any occupation charges, thereby giving rise to severe loss and damage to the petitioner. So his claim in the second arbitration is on account of occupation charges or mean profits. Paragraph I, my lord. Till date, the respondents directly as well as through the unauthorized sub licensees inducted by the respondents continued to be in actual physical possession of the demise premises and are commercially exploiting the same and generating huge profit therefrom at the cost and detriment of the claimant without even paying any sum on account of occupation charges. The claimant has ascertained from a cash memo, the invoice which I've already shown your lordship today, evincing a recent transaction from the demise premises that business is being carried on by Future Retail Limited. So he says it's Future Retail Limited, not me, not the respondents. He doesn't use the word respondent. It also transpired that tax deducted at source, TDS, in respect of license fee payable under the sub-license agreement has also been paid by Future Retail Limited for many years. From the relevant cash memos issued by the entities run and managed by the respondents and TDS Form 26AS obtained from the income tax website, it would be palpably clear that the respondents are still in occupation of the demise premises and are carrying on with their commercial activities in an unimpeded manner and are thus liable for payment of occupational charges or mean profits. The respondents are thus accruing regular income from the business activities from the demise premises at the cost and detriment of the claimant. So, my lord, these are the only two sets of documents he has to somehow prove that I am in possession. There is no other document, and that is clear from his pleading also. Paragraph J, my lord, the respondents are in wrongful possession of the demise premises at measuring an area of so-and-so, originally sub-licensed to them under the agreement January 30, 2007, and were obliged thereunder to pay license fees together with all escalations thereon and other charges in terms of the said agreement. As on 31st October 2011, that is the date on which the termination letter was issued, which has been accepted by him, by Agri Properties and Services Limited, now known as Future Market Networks Limited, my client. The licensee payable was 21.45 per square foot, amounting to 24,03,065 per month, which stood enhanced, etc., etc. Kindly turn over to the page, my lord. Then, my lord, he's given a table, my lord, in the center of the page, statement of outstanding license fees with interest at 18% per annum from August 2013 to August 2021. This is his assessment of his entitlement. Kindly come to the bottom of the page, paragraph K. The claimant would have been entitled to earn. My lord, I pause here for a moment. Would have been entitled to. So, my lord, purely speculative, unliquidated, unascertained. The claimant would have been entitled to earn from the said property at least the aforesaid amount of rupees such and such as mentioned herein above, considering the aforementioned rates for occupation of the said property as the minimum letting out value during relevant time as agreed and stipulated in the said agreement dated January 2007, had the possession been delivered to the claimant either upon termination effected by the letter dated October 31st, 2011, or upon passing of interim award dated 8th April 2013. Without prejudice to the aforesaid, the claimant has, however, claimed in the instant reference mean profit at the rate of rupees 60 per square foot per month up to May 2021. That is until filing of the instant statement of claim, and rupees 70 per square foot on and from June 2021 till recovery of possession of the demise premises. So, my lord, he is claiming at 60 rupees per square foot and 70 rupees per square foot. So, he is also acknowledging that A, his claim is unsecured, and B, his claim is unliquidated, which has to be determined upon adjudication in the arbitration. My lord, your lordship is.
Yes.
May I come back next Thursday, my lord? I'm in some difficulty tomorrow.
Tomorrow.
I'm in some difficulty. I'll come back next Thursday, my lord.
Okay. First. Argument on behalf of the respondent hard in part. Let the matter fixed on 27th
Grateful, my lord.
at 2 p.m. under the same heading. Yes, second one. Note. Abba.
I was suggesting now 698 is over. Can I start my 822 from tomorrow onwards, my lord, if it is convenient for my lordship? 698 is over. We are required to file the notes only.
Let it fixed on. Tomorrow I don't have any origin side matter. That's it. It is running in the list. Okay, okay. It would appear automatically. Very.
What's matter? 2 p.m.
Yes.